are reminded to exercise proper courtroom decorum and attire at all times. Specifically with folks, we are going to operate hybrid, meaning that I have people physically in the courtroom, as well as those who have elected and are being permitted to appear via Zoom. For particularly those who are appearing via Zoom, you cannot be in a vehicle. If you're in a vehicle, you have two choices. One, get out of the vehicle, find a quiet place to participate. Two, you can come down to County Court at Law Number 2, located at 300 De La Rosa, San Antonio, Texas, 78205. We are on the first floor of the Kadena Reese Justice Center, and you can participate in person. Those are the only two choices you have if you find yourself in a vehicle. Second, your name must be displayed, first name, last name. And it cannot be your phone's name. It cannot be your nickname. It must be your first name and last name. Third, you must have your video on. The people in the courtroom, I can see them clearly. And so when the court is addressing you or you're addressing the court, you must have your video on and be in good lighting so that I may see you clearly. Mr. Garcia, you'll need to go ahead and get in better lighting.
Yes, Judge.
So your posture, the people in the courtroom are sitting up. I need for you in the breakout, in the Zoom session, to be sitting up. Place your device on a flat surface. Place yourself in the center of your screen and then refrain from moving. There's a chat feature with the Zoom application. You cannot use that chat feature without my specific permission, except for one exception, and that is with the deputy, the bailiff in this court. He monitors the comings and goings in the court, as well as the court session. So you can chat to him if you need to leave the court session or you need for any reason and coming back. Also, the people in the courtroom, make sure that you talk to the deputy, let him know that you're stepping out to call your attorney, talk to your attorney, or to go to the bathroom if you need to. There will be no chewing gum, eating, drinking, vaping, or smoking while on Zoom. If you cannot do it in the courtroom, then you definitely cannot do it while on Zoom. You cannot leave the court session or the Zoom session, court Zoom session, without being properly excused from this court by me. If you do and you say, oh, my attorney told me I could leave, you may subject yourself to a warrant for your arrest. How we proceed this morning. Is I will call the docket, pretty short docket, so that shouldn't take us too long. I will call the docket. After I call the docket, I will move attorneys that need to confer with the ADAs or consult with a court coordinator. And then I will address individual issues that is of the business of the day for the court. So when I'm calling the docket, I will call the defendant's name 2 times. In the Zoom session, for those in court, I expect you to stand up, respond here or present, Sir, I'm still giving instructions. Attorney O'Donnell? I'm still giving instructions.
That was my fault.
I'm still giving instructions, calling the docket. I expect you to stand up, remain standing, and so that I may ascertain who your attorney is. So answer here or present. Then I will ask you, is this person your attorney? All I need is a yes or no. In the Zoom session, please unmute yourself, stay unmuted, and the same, answer here or present. And I will ask you regarding who your representative is. And all I need is yes or no. And then you can mute yourself back, or you can sit down. I will call your name twice. If I mispronounce your name, please make sure to correct me so that I may make my best effort to pronounce your name correctly. Attorneys, if you're to respond for your client, I still need to hear from the defendant so that I will be able to check both of you in. And attorneys, when you are announcing, please make sure if you need to confer with the ADAs or the court coordinator, please let me know so that we may mark up the docket, and that will expedite moving you to talk with the ADAs. Again, if you are in a vehicle, your name is not displayed, or you do not have your video on and you're not in good lighting, what I will do is I will tell you that I'm not recognizing you because of one of those issues. And you will have time, I'll give you time to be able to fix it. For instance, your name, if you need to rename yourself, all you have to do is hover over your frame, and then you can click on the three dots that show up, and it should give you an opportunity to rename yourself. Once you fix the issue, I will recognize you. Once I have finished calling the docket, I will ask, have I missed anyone? Is there anyone that I have not called their name, have not heard their name called, or I have not recognized? I will start out with the courtroom first, and then I will address the Zoom session so that I make sure that everybody is recognized. If you do not respond at that time, if I have not recognized you, I recall I will go ahead and mark you as FTA, failure to appear, until you make that correction. Then I will, once you're corrected, I will go ahead and mark you late. Any violations of these instructions are subject to contempt of court. Again, good morning. Today is Friday. It is the second day of December 2022, and I am looking for the following persons. Deputy, I'm going to start calling the docket, and at this time, anybody who enters, you'll need to go ahead and place them and note anyone who enters this Zoom session late. Emilia Benavides. Emilia Edith Benavides. Good morning, ma'am. Is your attorney Mike Machak?
My child, Judge, I did the notice for retained counsel on that last night, pursuant to the court order, no finding of that. I apologize for not having that sooner, but I did file the notice for retained counsel yesterday. We do technically require separate. I apologize for that error on my part.
Not a problem, sir. Thank you so much for being here. Thank you, ma'am. Go ahead and have this. Terrell Hayworth. Terrell Scott Hayworth.
Here, Your Honor.
Good morning, Mr. Hayworth. Is your attorney Zachary Munoz?
Yes, Your Honor.
Very good. We'll go ahead and wait for him. Thank you for being here, sir.
You're welcome.
Kenneth Huffhines. Kenneth Ray Huffhines.
Present with counsel,
Here.
Your Honor.
Kenneth Huffhines.
Here, Your Honor.
Okay, thank you. Good morning. Thank you, counsel, for being here.
Thank you.
Thank you.
Bobby DeLeon. Bobby DeLeon Jr.
He's present on Zoom with counsel, Your Honor.
Bobby DeLeon Jr. You need
He's
to
waving
respond.
at you, Mr. De Leon. There you go.
Unmute and
Right,
respond.
I'm unmuted now.
Okay.
Here.
All right. Thank you, sir. And I have Shannon Locke as the attorney of record who's announcing for.
Correct, Your Honor. Kim Gonzalez here. I'm appearing for Mr. Locke this morning.
Good morning, counsel. Thank you for being
Good
here.
morning.
Please unmute and respond. Danny Ars. Danny Ars. Mark as failure to appear. Potentially. Rigoberto Vargas. Rigoberto Vargas.
Present, Your Honor.
Okay. All righty. Thank you very much, sir. Appreciate you being here. Antonio Barbosa. Antonio Barbosa. Mark as potential failure to appear. Robert Merchant. Robert James Merchant.
Andrew Priest, I was present for Mr. Merchant, Your Honor. I don't know if he is here this morning. We were set for February 3rd. I received a Zoom link Wednesday evening for this morning and tried to reach my client to let him know that I received that email, but I was unable to reach him. So I don't know if he has notice of today's setting as opposed to the reset date of the 3rd of February.
Thank you, counsel. Please let me know when he arrives. Emma Anderson, Emma Grace Anderson.
Good morning, Your Honor. This is Joseph Strickland here for Trey Porter Law. Ms. Anderson is also present with us on Zoom. Ms. Anderson, you can go ahead and let the judge know you're here.
Sorry.
No problem. And we have a plea ready on that one, Judge.
Thank you, counsel. Emma Anderson, unmute and respond.
Here, Your Honor.
Thank you. David De Leon, David Christopher De Leon. Deputy, would you check for me on that one if he is in jail? David, okay. David De Leon, unmute and respond.
Here, Your Honor. Here, Your Honor.
Good morning, Mr. De Leon. Is your attorney Michael Goins?
Yes. Yes, Your
Very
Honor.
good. We'll wait for him. Thank you much for being here. Adrian Hubbard, Adrian William Hubbard.
And I'm here for him, Judge. We were set for a plea today. I'm not sure why he's not here. I've emailed him and texted him. I'll try to get him in here, Judge.
Please let me know when he gets here. Thank you, counsel. I appreciate
Yes,
you.
Your
being
Honor.
here.
Good morning.
Jacob Garcia, Jacob Nathaniel Garcia.
Here, Judge.
I'm present as well, Judge.
Okay, very good. Good morning.
Morning.
Richard Albert Hasek. Richard Albert Hasek. Hoshek, thank you very much, sir. Is your attorney Jerry Kagan? Very good. We'll wait for him. Thank you for being here. Paul Wayne Chapko. Paul Wayne Chapko.
I'm here, Your Honor.
Good morning, sir. Is your attorney Ronald Zimmerman?
Yes,
I never knew.
Okay.
yes, Judge, I am present for Mr. Chopko.
Thank you so much, sir. Jamal Luwan Bond. Good morning, sir. Is your attorney Oscar Hernandez? Okay, very good. We'll go ahead and wait for him. Appreciate you being here, sir. Is there anyone in the courtroom who has not heard their name or I missed? Anyone in the courtroom, physically in the courtroom? Okay. Is there anyone in the Zoom session that I have not called or who has not heard their name or have not recognized? Is there anyone in the Zoom session that I have not called or have not recognized?
Yes, Your Honor. Michael Ramirez.
Okay, Mr. Who's your attorney, Mr. Ramirez?
David Christian.
Anyone else? I've got you both checked in. Anyone else? All right, that concludes the calling of the docket. Who is the conferring ADA? Are you guys gonna jump on Zoom for the ones that are on Zoom? Okay, all righty. Anyone that needs to be moved under Zoom to be able to talk with the ADAs?
Judge Kim
Anyone
Gonzalez, if I may confer with an ADA.
Okay.
Yes, this is Adam Crawshaw to confer.
Thank you.
Judge Margaret Gallegos, to talk to the ADA to make sure she has all the plea paperwork.
Okay.
So Kenneth has signs. Thank you.
Okay. Oh, okay. Thank you. Um, Attorney Crawshaw. Okay. Okay, is there anyone else that needs to go ahead and get in with the ADAs?
Yes, Judge, this is Ron Zimmerman. If I may speak to the state, please.
Okay. The priorities today are to, there's ones that are set for hearings. I'm going to check for the pleas, ones that are set for pleas, and then I will address the business of the day as far as the docket is concerned. I'll be moving down the docket in order. So if you have a copy of the docket, I will be moving from page 1 to page 2. If you need to refer to your case, please use the number, the docket number, and it will be much, it expedites my being able to find the case on the docket. Excuse me a second. All right, thank you.
Judge, this is Joseph Strickland. Would it be possible to get in a breakout room with my client?
Yes, sir. And who's your
Thank you,
client?
Judge. It's Emma Anderson. Thank you, Judge.
All righty, sir. Mhm.
Number 9. 290 first. And now he's back.
Okay, thank you. Okay, so the only person set for plea that I do not have the paperwork for is a Bobby De Leon, and I guess the attorney is talking with the ADAs regarding that. Otherwise, I will go down the docket as far as the plea is concerned. Cause number, DAs, if you will note, cause number 673-168, 681-760, and number 14 on the docket, 683-128. This is a good time. If you have not heard from your attorneys or you haven't seen your attorney, please go ahead and contact your attorneys. Let them know that you're here in County Court 2 waiting for them, and the court will break at 11:30. At 11:30. and resume in the afternoon, probably about 1 o'clock. Council, before I get started.
I have an agreed order on the writ of habeas corpus on the evening of the meeting. Certificate of return have agreed to it. We're gonna submit a dismissal. This is on the individual that have no conflict on deferred possession of marijuana in 2010. At the time, certain she did the huge restricted had she remained in the U.S. permanent resident, there is no danger under the basis of citizens, but the minute permanent resident steps out of the country with the deferred, considered the conviction and makes him instantly deported to the situation she found herself in now. She is presently subject to deportation proceedings because of this case, and obviously there's no way to interview no intention to agree to sign off.
Great. I'll need that on record. So give me a second, sir. Thank you. Appreciate your patience. Mhm. Counsel?
My client has been taken into custody.
Yes, sir.
On a felony.
Yes, sir.
I wondered if I could reset this case. I asked and your board member gave me February 17th.
Reset it for what purpose?
For this case, for status, it's actually been deemed incompetent. And they already had the evaluation, but he hasn't been processed on the new felony charge yet.
Who's your client?
Rigo Berto Vargas, case number 680-837.
And he has a finding of incompetency?
Already, yes, Judge.
When did that happen? Do you know?
I'm sorry, Judge.
When did that happen? I found incompetent.
November 14th. There's recommended doctors recommending outpatient respiration. I'm in contact with his mom and dad, and hopefully they'll be able to post bond once he's actually.
And oops, I just rolled over. Your reset?
I'm hoping for February 17th.
Okay. Do you have that handwritten since both of you are here? Hard copy
I
of
can
it?
go ask. All I got was the date. We wanted to make sure the court was okay with it.
I'm fine with it.
I'll go get the form then, Judge.
Okay, thank you. I'll note on it. 2 seconds. Hang on 2 seconds. Let me just give you the file. That'll be one less one I have to deal with here.
It's supposed to be at the mental health graduation, and it's going to be very tight.
I'm gonna try and get over the 11:30 to do it. Take pictures.
He's going to have those right afterwards. That's what I thought.
They got the clue. He's at a 186.
Yes, Judge.
Thank you, counsel. Appreciate it.
Thank you, Your Honor.
Okay, Attorney, Hernandez, Flavio Hernandez.
Good morning, Judge. I'm sorry
Good morning,
to, I'm sorry to interrupt, Your Honor. I'm in no condition to be in court this morning. I've been sick in bed for going on 10 days now.
Yes, sir.
We're set for,
Sorry to hear that, sir.
thank you, Judge. I hope to survive, but one of these days, one will be the last one, won't it? It's a good reminder of mortality, let me tell you.
Yes, sir.
Your Honor, we're set for trial on Monday, and because of my illness, I have not been able to prepare as I need to prepare. I filed a second motion for continuance about 2-3 days ago, and I'm asking for 2 weeks, Your Honor.
Counsel, if you would, please go ahead and get some rest. Let me take care of the please, and then I will hear that motion, okay? Please, please, again, be resting, and I will definitely call your case, okay?
Yes, ma'am.
Attorney O'Donnell.
Yes, Your Honor.
How long does it take to get? How long does it take to get?
You mean where for me, if I'm really lucky, 15 minutes. Okay. I go down St. Mary's.
Down
No,
St.
is it
Mary's?
St. Mary's? No, it's in St. Mary's. It's right by St. Mary's University. It's on the way to St. Mary's.
Oh,
I think it's a good neighborhood.
Right.
I have to put it on my phone.
right, okay,
I got lost last time,
okay.
and I've been there before. Is that terrible?
No, sounds like me. State, are you ready to proceed on the pleas as I call them out? Okay. State, will you remain there? And do you have a microphone? Okay, all right. Attorney Margot Gallegos. She's checking on the paperwork. Would you please jump in there and tell her that she can come out? Yes, I have the paperwork. Okay. Attorney Strickland? Attorney Joseph Strickland?
Yes, Your Honor.
Okay. Attorney, Wood. Attorney Wood? Okay. Are you ready? Okay, not a problem. The Anderson 681-760. State, are you ready on, while we wait for the other attorneys on cause number 681-760, ready to proceed on that one?
Yes, Ron, looks like we can get it there, yes.
Let us get on record. Court is going to call the case number 681760, the matter of the state of Texas versus Emma Grace Anderson. Parties, please approach and identify who is before the court, starting with the state.
Victor Hernandez with the state.
And Joseph Strickland for Ms. Anderson, who is also present on Zoom.
Emma Grace Anderson,
Yes, Your Honor.
are you Emma Grace Anderson, the same that has been accused of driving while intoxicated, alleged to have occurred on the 25th of March, 2022, classified as a Class B misdemeanor? Are you the same so accused?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth, under pains and penalties of perjury, so help you God?
Yes, Your Honor.
You may go ahead and place your hand down. The defense is on Zoom while the state is in person. Therefore, the court will share the court screen. Ms. Anderson, can you see this court screen?
Yes, Your Honor.
Counsel, can you see the court screen?
I can, Your Honor.
State,
Oh,
you can see the court screen? State, on display is a document that's entitled State's Consent to Video Conferencing. Did you sign that document that's consenting to these proceedings by video conferencing?
but no, Your Honor, Assistant District Attorney Ling Han signed it, but the state adopts it, Your Honor.
Okay, and I just need for you to increase your volume so as to make sure they can see you, okay?
Yes, Your Honor.
This state's video conferencing consent is made part of the record. Defense, on display is a document entitled Defendant's Consent to Video Conferencing. Ms. Anderson, is this your signature where I'm circling the cursor?
Yes, Your Honor.
Did you sign this document thus consenting to plea by video conferencing?
Yes, Your Honor.
Counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
I do, Your Honor.
The defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Ms. Anderson?
Since the inception of this case, Judge, well over 10 days.
And are we applying for probation today? And if so, what type?
Deferred adjudication.
Thank you, counsel. Ms. Anderson, on display is a document that's entitled Application for Deferred Adjudication Community Supervision. This is your application and it's consists of 2 pages, along with your personal data sheet. This is the first page. And then this is the second page. I draw your attention to the middle of the page where I am circling the cursor. It states that you are the person, the defendant in this case. You appeared personally before me, albeit via Zoom. I have sworn you in, and under oath, you're telling me that your application for deferred adjudication community supervision, as well as the document entitled personnel data sheet, which is going to be attached as an exhibit to your application, is true and correct. Is that so? Is that true? Both documents, your application and your personnel data sheet, are they true and correct?
Yes, Your Honor.
Keeping in mind that if they're not completely filled in, they cannot be true and correct, especially with your personnel data sheet. Now, do you need to speak with your attorney to understand the consequences of your response to this statement, that the defendant understands and acknowledges that any untrue statement in the application or the personnel data sheet may be grounds for denial or revocation of any community supervision in this case? do you need to speak with your attorney before responding?
No, Your Honor.
Do you understand and then therefore, do you understand?
Yes, Your Honor.
Do you acknowledge?
Yes, ma'am. Yes, Your Honor.
I will sign the document, your application and personal data sheet are made part of the record. State, have you fulfilled your Brady and discovery requirements in this case?
Yes, Your Honor.
Counsel, are you satisfied that state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's files?
I am, Your Honor.
State, is a law enforcement disclosure in this case? Is this case subject to law enforcement disclosure? And if so, has it been complied with?
Yes, Your Honor, the state is compliant.
Okay. Counsel, you can hear the state?
Yes, Your Honor.
I will sign the discovery acknowledgement and make it part of the record. State, do you have any motions for the court's consideration at this time?
Yes, Your Honor, the state moves to waive and abandon count 1 and proceed on count 2, which is the obstruction charge class B misdemeanor.
Defense, what say ye to state's oral motion to waive and abandon count 1 and proceed to count number 2?
No objection.
State, without any objection, that motion is granted. State, do you have any other motions for the court's consideration?
Yes, Your Honor, the state moves the court to admit the state's exhibit 1 for the purposes of this hearing only.
Counsel, what say ye?
No objection to that, Judge.
Granted. State's exhibit 1 is so admitted. And state, where's your state exhibit 1?
Your Honor. That's strange. Looks like it's not in the it's not in the plea paperwork here. Not sure
You
what
know,
happened there.
Ling actually emailed it because it was too big to attach for some reason.
Oh. All right. Thank you, sir.
State, is this part of your state's exhibit 1?
Your Honor, it looks like it's indicating state's exhibit 1 there, but as I understand from defense counsel, it looks like the state actually emailed it to the court.
Yes, Your Honor. Ms. Han Martinez has actually emailed to the court on November 21st at 10:30 a.m. because it couldn't attach to the Adobe sign document. Do you want me to send it
State, you're
straight?
saying this is state, excuse me, counsel. Is
Sorry,
this
Judge.
state, this is your state exhibit 1 on display?
Your Honor, it looks like specifically that's the stipulation of facts and judicial confession. It is referring to state's exhibit 1.
Okay.
So I would expect it to be in the court's possession.
In the court file, I also have this package. It's ADA, is this part of it?
Hold on, Your Honor, let me just approach really quickly. Just to verify.
Counsel, defense, I also have this package. You can see it as part of the state's exhibit 1, correct, ADA?
Yes, Your Honor.
Ms. Anderson, on display is State's Exhibit 1. It is a compilation of a package of documents. Starts off with the stipulation of facts and judicial confession. This is a one-page document of which you and your attorney signed, as well as the state. Then the next document is motor vehicles in the household. It states here that you hereby swear that the following motor vehicles are possessed or owned by you or a member of your family or household where you live. The court observes that 3 vehicles have been listed and you have signed that.
Yes, Your Honor.
Next is a plea bargain document. Next is the waiver of appeal and post-conviction remedies. Sorry, going back to the plea bargain document, it indicates that you intend to enter a plea of guilty. With the waiver of appeal and post-conviction remedies, again, it indicates that you intend to enter a plea of guilty. All parties have signed that. And then here's another oath. It states here that you, again, are the person, the defendant in this case, and after swearing you in, you state and you're telling me that all the facts stated in the above stipulations and plea agreement are true and correct, specifically including the documents labeled state. And I have gone through and shown you all these documents. You have signed it. I will sign it, make it part of the record. Here it states that you, again, under this order, you intend to enter a plea of guilty. I am signing that document as well. That is State's Exhibit 1, and all these other documents are part of the police report. State, any other motions for the court's consideration? Defense, any motions for the court's consideration?
No, Your Honor.
Ms. Anderson. Document on display. Draw your attention to document on display is entitled Defendant's Waiver of Constitutional Rights and Course Admonitions. This is a 2-page document, this being the first page, and then this being the second page. Is this your signature where I'm circling the cursor?
Yes, Your Honor.
Did you review this 2-page document with your attorney?
Yes, Your Honor.
After reviewing it with your attorney, did you freely and voluntarily sign it?
Yes, Your Honor.
So with your signature and your testimony now, you're telling me that you understand everything in this 2-page document as it was reviewed and explained to you by your attorney.
Yes, Your Honor.
Are you satisfied with the representation of your attorney?
Yes, Your Honor.
He has done a great job for you in that he has removed the DWI from this and then lowered it from a DWI conviction to an obstruction, and now it's a regular Class B misdemeanor. Did he explain to you the range of punishment associated now with this?
Yes, Your Honor.
Did he explain, and you understood it, correct?
Yes, Your Honor.
And did he explain to you your constitutional rights?
Yes, Your Honor.
And you understood those?
Yes, Your Honor.
So with your understanding of constitutional rights, do you freely and voluntarily give them up?
Yes, Your Honor.
Are you a US citizen?
Yes, Your Honor.
I will approve your jury waiver. I am going to sign this document, make it part of the record. You will no longer be able to have a trial in this case. Counsel, do you believe that your client is competent to enter into a plea today?
I do.
Counsel, with the information, were you able to apprise this defendant of the nature of the offense and charges against her?
I was.
Do you and this defendant waive the formal reading of the information?
We do.
State, what is the punishment recommendation in this case?
Well, the state recommends 12 months of deferred adjudication, a fine of $250 plus court costs, 60 hours of community service. In addition to that, the state recommends the DWI education program and UImpact.com course, as well as the TAIP evaluation. And the state asks that the defendant follow all the recommendations from that evaluation. The state also asked for a ignition interlock for 6 months, Your Honor. And one moment, let me see if there's anything else. I think that's all, Your Honor.
Counsel, is that your understanding of the state's punishment recommendation to the court?
It is.
And Ms. Anderson, is that your understanding of what your attorney has worked out with the state on your behalf in order to dispose of this matter today?
Yes, Your Honor.
And with that understanding, how do you wish to plead? Guilty, not guilty, or no contest?
Guilty.
You're pleading guilty because you are guilty and for no other reason than the fact that you're guilty?
Yes, Your Honor.
I will accept your plea of guilty, finding that it is intelligently and freely made and that you're competent to do so. Counsel, what, if anything, on behalf of your client and why I should consider this plea?
Your Honor, I do want to point out that Ms. Anderson has completed the DWI education and UImpact. We filed those certificates with the court yesterday via e-file, and they were accepted. So they should be available. She has had zero issues while on bond in this case, Your Honor, and we would ask that you just accept this plea deal.
State, what was the BAC in this case?
Your Honor, that was 0.12.
Ms. Anderson, whom do you live with?
I live by myself.
Ms. Anderson, all your references share the same address as you do, parents and sister.
I live by myself, but I'm always at my parents' house. My mother is sick, so I'm always here taking care of her. But I do have an apartment of my own.
Understood. Thank you for that clarification. Do you have the ignition interlock on your vehicle at this time?
I do not.
State, do you have any objections to this defendant being referred to Bear County Gives Back program for community service restitution at least the first 40 hours?
No, Your Honor.
Counsel, you are familiar with the Bear County Gives Back program?
I am, Your Honor, and I discussed it briefly with Ms. Anderson before we started the plea.
Counsel, is there any legal reason why this matter cannot be disposed of today?
No, Your Honor.
Ms. Anderson, although there is sufficient evidence to find you guilty in this matter, I am going to withhold my finding of guilt and I'm going to place you on 12 months of deferred adjudication, community supervision, probation. You will be monitored and supervised by the Community Supervision and Corrections Department, otherwise known as probation, on behalf of this court with these following conditions: $250 fine plus court costs, 60 hours of community service restitution. I am going to refer you to the Bear County Gives Back program for first 40 hours only. You're responsible for the entire 60 hours of community service restitution. I will address this further in a minute. DWI Education, uimpact.com, and TAP Evaluation. Ignition interlock for half the term of which you will install within 10 calendar days. I will need an affidavit from you within 10 calendar days that states you will not drive any vehicle that's not equipped with an ignition interlock. I will require this, require your CSO to provide a status report in 2 months to advise the court how well you're doing on probation and conduct a field visit. I will set your supervision fee at $45. State, did I cover everything for you?
Yes, Your Honor.
And also, regarding the court will take judicial notice of the State, do you have copies of the completion of a DWI education program as well as the U-Impact?
One moment, Your Honor. It looks like we did receive those. It's like today. Let me double check here. Yes, Your Honor. It looks like we received those from the court. Looks like they were through e-file. Yes, Your Honor.
Do you have any objections of the court taking judicial notice of these documents? The completion, are you in agreement with the completion of these requirements prior to the plea?
No, Your Honor, the state has no problem with the court taking judicial notice.
Ms. Anderson, do you have submitted to your attorney documents of the Texas DWI education program, that date of completion, 25 August 2022, as well as the U-Impact certification of completion of that, dated the 22nd of August 2022. The court will take judicial notice of both of those certifications of completion and give you credit for the completion of those requirements. Make sure that you also have copies of those and present it to your CSO. And I appreciate you leaning forward in the foxhole with those. State, I've covered everything for you.
Yes, Your Honor.
Defense, anything further on this matter?
No, Your Honor.
Ms. Anderson, regarding the plea, the trial court certification of defendant's right of appeal, this has been a plea bargain case, and you have no right of appeal, as I have certified it and I have signed it. You will get a copy of this when you come down to provide us your fingerprints. Will you be able to do that Monday, Tuesday, or Wednesday?
I can do it Tuesday, Your Honor.
You will be coming down to County Court at Law Number 2, located at 300 De La Rosa, San Antonio, Texas, 78205. We're on the first floor of the Cadenas Reeves Justice Center. You will need to appear in this court between the hours of 2 p.m. and before 4:30 p.m. If you do not appear at that on the 6th of December, on Tuesday, the 6th of December, 2022, a warrant will be issued for your arrest. Do you understand that, Ms. Anderson?
Yes, Your Honor.
Now, your attorney has done a great job for you here. The way for you to truly appreciate his efforts on your behalf is for you to be successful on probation. 12 months is a long time to be under any scrutiny whatsoever. But if you have any issues while you're on probation, make sure to speak with your CSO. Communication is the key in being effective and successful on probation. And I look forward to your successful completion of your probation requirements. I want you to be successful. It's not only important to you as that this is a bump in the road for you. You have a long life to go. All righty, we pray. And so I want you to still be successful and continue to be a great contributing member of this community. Appreciate you being here to take care of this matter. Okay?
Yes.
You have yourself a great weekend. We'll see you on Tuesday. At that time, between now and then, my CLO will reach out to you, explain to you about the Bexar County Gives Back program, and determine whether you're eligible for it. It is optional. It is an alternative method for you to complete to go ahead and get credit for 40 hours of community service restitution if you wish to participate. It is not mandatory, so if you wish to participate, great. If not, you're still responsible for that 60 hours, okay?
Yes, Your Honor.
All righty, thank you so much. We'll see you on Tuesday. We're off record on this matter. Counsel, do you have anything further in this court?
No, Your Honor. Thank you.
Thank you so much. Have a great weekend. Appreciate you being here, sir.
Thank you, Judge. Ms. Anderson, you can go ahead and log off. I'm going to call you in a second too, okay?
Attorney Zimmerman, I need to go ahead and take care of the guys. Oh, I need to stop sharing. Attorney Zimmerman, priorities of folks inmates.
Yes, Judge, I'm here on Mr. Chopka. I was in the breakout room for the ADA and I got disconnected, so I need to get back into that breakout room. Judge.
Sorry about that. Okay, sir. Thank you. Okay. Anybody else need to be moved to speak with the ADAs?
I do need to be moved to speak with the.
Sorry, didn't hear that. Anybody needs to be moved to speak with the ADAs?
Your Honor, Margaret Gallegos for Kenneth Lines.
Yes, are you ready to proceed on the plea on your case?
Yes, ma'am, we are.
Okay. Attorney Wood.
Good morning, Judge. My client is Adrian Hubbard. I called his phone. He just rang and rang, so I called his mother. She said he went to work and he left his phone, and so she had him call me. He's out of county. I just would like it's a recall for Monday, possibly for a plea. He said, I signed all that paperwork. I'm on defer. And I said, no, you have to go in front of the judge. And he said, well, I have a contract. And I said, yeah, with the state, not with the court. Oh, so he's out of county. If I could ask you, could we recall him for Monday for a plea, Judge? Mr. Hubbard, Adrian Hubbard.
And why can he not participate in Zoom this afternoon?
I possibly could. I'm out of county this afternoon, but he doesn't have a cell phone. He's called me on some friend of his phone. I don't have any idea what the capability of that is. But I have to go to Carnes this afternoon, Judge. I was in hopes I could just recall him for a plea.
Thank you, counsel. This is what I will do. I will go ahead and issue a judge's warrant and remand your client without bond on the 5th of December, 2022. So what he'll need to go ahead and show up on the 5th of December, 2022. And so that we may be able to go ahead and take this plea. He needs to report into the courtroom in person on the by 8:30 a.m. If you would, I'm going to place you in the breakout room with the court coordinator so as to get a case raise set form to you, and you'll be able to share that with your clients.
Thank you, Judge. Thank you very much. And I'll have him there Monday morning.
Thank you so much, counsel. You may be excused from there. Appreciate your time.
Thank you, Judge.
Yes, sir. Attorney Kim Gonzalez. I don't have the paperwork on your client.
No, Judge, we haven't received it yet, and I was going to ask if I could please be placed in a breakout room with Mr. Babadillion.
Yes, ma'am. Thank you.
Thank you.
Counsel, you need opportunity to be able, capability to share screen, perhaps?
Well, not at the moment, Judge, because I haven't received the paperwork.
Okay. Will you need the opportunity, the capability to share screen?
No, Judge.
Will you? No?
No, ma'am.
Okay. Attorney Munoz?
Good morning, Your Honor.
should have
I'm
your
here on Carol Hayworth. I believe it was a PTC setting. Or maybe not. No matter what it was, I guess, state tendered a motion to dismiss. I believe there was some correspondence between the state and your office. I think I replied to that email chain regarding the motion to dismiss. I just wanted to see if the court was going to, I guess, grant that motion, or if we needed to have a hearing on it, or what was, I guess, the status of that.
Okay. If you would go ahead and get into the breakout room with the ADA and be able to determine what's the status of that, okay? All righty, thank you. We'll go ahead and place him in the breakout room with the ADA. All righty, let us get on record. Court is going to call cause, State, you have cause number 673-168.
Oh, yes, Your Honor.
Let's get on record on cause number 673-168. The court is going to call the matter of State of Texas versus Kenneth Ray Huffines. Parties, please approach and identify who's before the court, starting with the state.
Turn on for the state.
Defense?
Margaret Bianca Gallegos for Kenneth Huffines.
Kenneth Huffines, present.
Are you the same Kenneth Ray Huffines that's been accused of driving while intoxicated with an open can, alleged to have occurred on the 6th day of November 2021 and classified as a Class B misdemeanor? Are you the same so accused?
Yes, Your Honor.
All right. Sir, you're coming over wobbly as if you are Darth Vader. So just wanting to, I don't know if your connection is waning, but
Is the voice wobbly or the entire connection video as well?
You kind of keep going in and out, just letting you know if you get this, just to, I don't know what's going on, but you need to make sure you don't get disconnected, okay? All righty, let's go ahead and proceed. Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth, under pains and penalties of perjury, so help you God?
Yes, I do.
Thank you very much, sir. You may go ahead and lower your hand. The court is going to start sharing the court screen as we're operating hybrid, and the defense is on, the defendant and the attorney are on the on Zoom, and state is in person. Mr. Huffines, can you see the court screen?
Yes, Your Honor.
Counsel, can you see the court screen?
Yes, Your Honor.
State, you can see the court screen?
Yes, Your Honor.
State, on display is a document entitled State's Consent to Video Conferencing. Did you sign that document that's consenting to these proceedings by video conferencing?
Your Honor, Assistant District Attorney Ling Han signed it, but the state adopts it.
State's video conferencing consent is made part of the record. Counsel, defense, on this display is a document entitled Defendant's Consent to Video Conferencing. Mr. Huffines, is this your signature when I'm just circling the cursor?
Yes, Your Honor.
Did you sign this document thus consenting to plea by video conferencing?
Yes, Your Honor.
Counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
Yes, Your Honor.
The defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Mr. Huffines?
Since he was arrested, Your Honor, so that would be.
Would that be greater than 10 days?
Yes, Your Honor.
And are we applying for probation? And if so, what type?
We're applying for deferred adjudication, Your Honor.
Thank you. Mr. Huffines, on display is a document entitled Application for Deferred Adjudication Community Supervision. This is your application. It composes of 2 pages. I draw your attention to the second page in the middle of the second page, whereby I am circling the cursor. It states that you personally appeared before me, albeit via Zoom. You are the defendant in this case. I have sworn you in under oath. You're stating that your application for deferred adjudication community supervision and the document entitled Personal Data Sheet, which is going to be attached as an exhibit to your application, are true and correct. Is that so, Mr. Huffines? Are both of those documents, the application and the personal data sheet, true and correct?
Yes, Your Honor.
Understand under oath that if any information is, if it's not completed, it cannot be true and correct. Do you need to speak with your attorney to understand the consequences of your response to this statement? Defendant understands and acknowledges that any untrue statement in the application or your personal data sheet may be grounds for denial or revocation of community supervision in this case. Do you wish to speak to your attorney first?
No, Your Honor.
So you understand, and you understand, sir?
Yes, Your Honor.
And you so acknowledge?
Yes, Your Honor.
I will sign the document, making the documents part of the record. State, have you fulfilled your discovery and Brady requirement in this case?
Yes, Your Honor.
And counsel, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Code of Criminal Procedure, as well as giving you full access to the state's files?
Yes, Your Honor.
State, is this matter subject to law enforcement disclosure? And if it is, has that been complied with?
Yes, Your Honor, status compliant.
I will sign the discovery acknowledgement, making it part of the record. State, do you have any motions for the court's consideration at this time?
Your Honor, the state moves to waive and abandon count 1 and its open container enhancement and proceed on count 2 for obstruction by intoxication as a Class B misdemeanor.
Counsel, what say ye to the state's motion, oral motion?
No objection, Your Honor.
Without objection, state's oral motion is granted. State, any other motions for the court's consideration?
Your Honor, the state moves the court to admit State's Exhibit 1 for the purpose of this hearing only.
And where's your state exhibit 1?
Your Honor, it should have attached to the documentation further below.
Okay. Counsel, what say ye to state's motion?
No objection.
Without objection, the state's exhibit 1 is admitted. State, is this your state exhibit 1?
Yes, sir, and the documentation should be at the bottom of the document.
Mr. Huffines, the state's exhibit 1 is a package of documents. It's the state's exhibit 1. It starts out with stipulation of facts and judicial confession. So it's a 1-page document. And the next document is motor vehicles in the household, whereby it states that you swear that the following motor vehicles are possessed or owned by you or a member of your family or household where you live. And it indicates here there are 2 vehicles.
That's correct, Your Honor.
Next is a plea bargain agreement whereby it indicates that you intend to plead guilty.
That's correct, Your Honor.
And then next is a waiver of appeal and post-convictions remedies where it indicates that you intend to plead guilty. And then there's oath whereby it states that you're appearing before me in person, albeit via Zoom, that you have been duly sworn in. Under oath, you are stating that all the facts stated in the above stipulations and the plea agreement are true and correct, specifically the documents so labeled, and I have shown you and read the labels to you. I will sign it and making it part of the record. And then as far as the order is concerned, it states that you intend to plead guilty. I'm going to sign that. The state's exhibit 1 is admitted for record. State, any other motions for the court's consideration?
No, Your Honor.
Counsel, any motions for the court's consideration?
No, Your Honor.
Mr. Hupkins, on display is a document entitled Defendant's Waiver of Constitutional Rights and Course Admonitions. This is a 2-page document. This is the first, this is the first page, and then this is the second page. Is this your signature where I am circling the cursor?
Yes, Your Honor.
Did you review this document with your attorney?
Yes, I did.
After doing so, did you freely and voluntarily sign it?
Yes, Your Honor.
So with your signature and testimony, you're telling me that you understand everything in this 2-page document as it was reviewed and explained to you by your attorney?
That is correct.
That's a yes, sir?
Yes, Your Honor.
Are you satisfied with the representation of your attorney?
Yes, Your Honor.
She has done a wonderful job for you, being able to remove 2 counts on this matter. And the open container, as well as reducing this to a regular Class B misdemeanor. She has done a wonderful job for you. Did she explain to you the range of motion in this case?
Yes.
And you understood them?
Yes, Your Honor.
And then she explained to you your constitutional rights and you understood those?
Yes, Your Honor.
With that understanding, sir, do you freely and voluntarily give up your constitutional rights?
Yes, I do.
Are you a U.S. citizen, sir?
Yes, Your Honor.
I will approve your jury waiver. I am going to sign it, make it part of the record. You will no longer be able to have a trial in this matter. Counsel, with the information, were you able to apprise this defendant of the nature of the offense and charges against him?
Yes, Your Honor.
Do you believe that your client is competent to enter into a plea?
Yes, Your Honor.
And do you and your client waive the formal reading of the information?
Yes, Your Honor.
State, what is your punishment recommendation in this case?
Your Honor, the state recommends 12 months of deferred adjudication, $250 fine plus court costs, 60 hours of community service restitution, PWI education, the U-Impact program, TAIP, and all recommendations for the defendant to follow, and the ignition interlock for half the term, Your Honor.
Counsel, is that your understanding of the state's punishment recommendation in this case?
Yes, Your Honor.
And Mr. Hupkins, is that your understanding of what your attorney has worked out with the state on your behalf in order to dispose of this case today for you?
Yes, Your Honor.
With that understanding, sir, how do you wish to plead? Guilty, not guilty, or no contest?
Guilty.
And you're pleading guilty because you are guilty and for no other reason than the fact that you're guilty?
Yes, Your Honor.
I will accept your plea of guilt, finding that it is intelligently and freely made and that you are competent to enter into this plea. State, you indicated here that there was a restitution to for I guess to $60 restitution to Texas DPS. You are waiving that as it was not mentioned in your plea bargain? You, to the court.
I apologize, Your Honor. It looks like that was not in my notes, but it was in the plea agreement, and the state does recommend that unless there's a strong objection from the defense.
Defense, is that your understanding with the $60 restitution to Texas DPS?
Yes, Your Honor.
Mr. Huffines, that is your understanding as well?
Yes, Your Honor.
Counsel, what, if anything, on behalf of your client, and why should I accept this, consider this plea?
Your Honor, this was an isolated incident, and my client respectfully asked the court to agree to this deferred adjudication, and he will adhere to all of the terms, and he understands the gravity and the seriousness of the potential consequences if he does not comply with the terms of the deferred adjudication, and that there could be, jail time if you so choose for any violation. Therefore,
Thank you, counsel.
Thank you.
Sorry,
Okay.
proceed. Sorry, finish up.
Your Honor, we just really respectfully hope that the court will accept this plea agreement that we've entered with the state. And my client understands that the state is taking a big chance on him as well as this court, and he will not let the court or the state down in agreeing to this agreement.
Thank you very much, counsel. That is very insightful and very helpful. Mr. Huffines, whom do you live with?
My wife?
Does she have a vehicle?
Yes,
Is that the second vehicle that was listed on the motor vehicles in the household?
that is correct, Your Honor.
What's your wife's name, please?
It is Christy Davis Huffines.
Is Christy spelled in the normal sense with a CH or is it with a K?
It is with a K, Your Honor.
Okay. Say, what was the BAC in this case?
Your Honor, that was 0.138.
Mr. Huffines, do you have the ignition interlock on your vehicle at this time?
No, Your Honor.
Please describe to me what year, make, model, and color the vehicle that the ignition interlock is going to be placed on?
It is going to be on the 2014 Kia Cadenza. Black in color.
State, do you have any objections with the court referring this defendant to the Bexar County Gives Back program?
No, Your Honor.
Counsel, are you familiar with the Bexar County Gives Back program?
Yes, I am, Your Honor, and we have no objection.
Counsel, is there any legal reason why this matter cannot be disposed of today?
No, Your Honor.
Mr. Huffines, although there is sufficient evidence to find you guilty in this case, I am going to withhold my finding of guilt and I'm going to place you on 12 months of deferred adjudication community supervision to for obstruction of highway. You will be supervised and monitored on behalf of this court by the Community Supervision and Corrections Department, otherwise known as probation, with these following conditions: $250 fine plus court costs, 60 hours of community service restitution, of which I will refer you to the Bexar County Gives Back program for first 40 hours only. You'll be responsible for the whole 60 hours. DWI education, uimpact.com, tap evaluation, ignition interlock for half the term to be installed within 10 calendar days. $60 restitution to the Texas Department of Motor Vehicles. Sir, I will require 2 affidavits from you within 10 calendar days. The first one will be from you that you will not drive any vehicle that's not equipped with an ignition interlock. The second will be from your wife, whom you have identified as Christy Davis Huff Hines, and owns a vehicle and lives with you. And she will not let you drive her vehicle under any circumstances. Otherwise, sir, I will order ignition interlock to be placed on that vehicle as well. She will identify her vehicle by year, make, model, color, license plate number, and the last 6 digits of the vehicle identification number. I will set your supervision fee at $50. And I will ask the CSO, your community supervision officer, your probation officer, to conduct a field visit. State, did I cover everything for you?
Yes, Your Honor.
And I did state the supervision fee to be $50. Counsel, anything further on this matter?
No, Your Honor.
Mr. Huff-Hines, with regards to the trial court certification of defendant's right to appeal, this has been a plea bargain case, and I am certifying that you have no right to appeal. You'll pick up a copy of this document when you come down to the courthouse to provide us your fingerprints. Will you be able to do that Monday, Tuesday, or Wednesday next week?
Tuesday.
Sir, you're going to be coming down to County Court at Law Number 2, located at 300 Villa Rosa, San Antonio, Texas, 78205. We are on the first floor of the Kadena Reeves Justice Center. You will be coming between the hours of 2 p.m. and before 4:30 p.m. Understand that if you fail to appear, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, Your Honor.
Well, Mr. Huff-Hines, with the community service restitution and referral to the Bexar County Gives Back program, between now and the time that you come down, the CLO should be in touch with you to explain that program and determine your eligibility for it. Now, I provided as an alternative means for you to be able to satisfy the community service restitution. If you do not wish to participate in it, fine. If you do, you will be able to go ahead and satisfy at least 40 hours of your community service restitution. You're responsible for all 60. I look forward to your successful completion of your community supervision and your continued contribution to this community, sir. And now, within the 12 months, if there's any issues that may impede your successful completion, sir, please make sure to talk to your CSO about that, so that, as your attorney has stated, that this court will not have any problems with you completing your community supervision and that you have understood the gravity of this opportunity that you have been given. And I believe your attorney, she has done a wonderful job for you. And the way for you to thank her is for you to be successful.
Thank you,
Look
Your
forward.
Honor.
Thank you, sir. Appreciate you coming and taking care of this matter. And we'll see you on Tuesday, okay?
Look forward to it. Thank you, Your Honor.
Thank you. Counsel, do you have anything further in this court?
No, I don't, Your Honor. I ask to be excused and happy holidays.
You too. Thank you very much. Enjoy it.
You're welcome.
And thank you so much. You are excused.
Thank you.
Judge, I apologize. This is Andrew Priest for Robert Merchant. May I approach briefly?
Yes, sir.
As I mentioned earlier, I believe Mr. Merchant is now on Zoom.
Okay.
We were set for February. I received notice Wednesday to appear today. However, I have to log off in probably 2 minutes. I have an appointment at my son's school and am unavailable this afternoon, but Mr. Merchant has logged on.
All right. Robert James Merchant,
Yes.
please unmute and respond.
Yes, Your Honor, I'm here.
Okay, very good. What we can do, counsel, we should go ahead and recall this for Monday.
Okay.
All right. Just so that you can get going, okay, sir? And Mr. Merchant, you will be here Monday by 8:30 a.m., okay? You can participate via Zoom, I believe. So we'll see you at 8:30 on Monday, and please don't be late, okay?
And I
Yes, ma'am.
believe, Judge, you had we were reset for February. When we were in court last time, you ordered, I believe, an affidavit of non-driving for Mr. Merchant. I just wanted to make sure I had emailed that to Mr. Merchant. I don't believe he knew I had emailed it to him. I think it maybe ended up in his junk folder, but I believe he has it now. He just needs to print it and get it back to me for filing. I just wanted to make sure that that was all the court was requiring, so there'd be no issue.
I appreciate you. You had expressed to me the urgency of your departure. If you, at the time, you wish to go ahead and approach the court on Monday regarding this, unless you wish for me to go ahead and look into it. But
Okay.
I
will
right
do
now
that then, Judge.
focusing. Okay, all right, sir, that'd be fine. Thank you.
Okay, thank you.
I'm considerate of your time and
Of course,
And
thank
mine.
you, Judge. We'll appear on
Okay.
Monday.
all righty. Thank you.
Your Honor, may I have this motion to dismiss?
Please approach. Let's get on wrap. Well, hang on a second. I need to go ahead and take care of the state of the inmate cases. Attorney Zimmerman,
Yes, Judge.
on Chapco.
Yes, Judge. If I could confer with the state one more time, I think we're close to at least an agreement between the state and the defense on this MTR. Although my understanding is that there is not a representative for the probation department available today.
No, this is true. But we'll go ahead and let me go. She's not on, and so let me go ahead and let's see what we can do. Go ahead while you're coordinating that. Thank you for that reminder. While you're coordinating that, I will let you know when you come back regarding probation. Okay, sir?
Okay. All right. Thank you, Judge.
Council, you should still have access to the breakout room.
Yes, Judge. It's going to put me into breakout room number 4. And then-
Okay, sorry about that. Please put him with the ADAs.
Thank you, Judge.
Your Honor, may I approach?
Give me 2 seconds, sir. Attorney Strickland, I'll be with you this afternoon, okay? If you go ahead and just approach the court, thank you.
Okay, thank you, Judge.
Yes. Around about 1 after 1, please.
Your Honor, may I approach?
Give me 2 seconds and definitely so.
Sure thing, Judge. Thank you. I just have a short matter.
Oh, yeah. Oops. Attorney Javier Garcia. Attorney Javier Garcia.
Your Honor, I believe he's going over paperwork with the client. We're kind of here together on Mr. DeLeon because I have to be out of town this afternoon. So he's just on standby in case he needs to cover the plea, if that's okay with the court.
Great. And I have 2 DeLeons on the docket. Yours is
Bobby, Judge. It's not the gentleman that's in custody. He's on bond and he's actually at the office. So we're just going over paperwork right now.
Gotcha. Okay, sounds right. Okay. Okay. Okay.
Oh, I gotta.
Okay, before breaking, I am going to try to accommodate matters, docket number 1, that is Benavides case, the Hayworth case. Chapco Ramirez, Michael Ramirez case, and De Leon, and also Crawshaw. I will address that matter very quickly. I will see the rest of you back at 1 o'clock, 1:15, the very 1:15, please. Thank you. Please let your contact your attorneys, let them know that you're here waiting for them, and I'll see you at 1:15 if I did not call out your name. Court is going to get on record on cause number 253857, State of Texas versus Emilia Edith Benavides. Parties, please approach and identify who's before the court, starting with the state. Are you Emilia Edith Benavides?
Yes.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth under pains and penalties of perjury, so help you God?
I do.
Thank you very much. You may go ahead and lower your hand. Counsel, I have sworn your client in regarding, I believe that you're here on a matter of habeas corpus.
That's correct, Your Honor.
Okay, and state you have a copy of that document. It doesn't look like it was e-filed.
Your Honor, it looks like defense showed it to our office.
I was dealing with the other assistant district attorney, Your Honor, who's already signed off on that order.
All righty. It is your order for an application for writ of habeas corpus under Article 11.072 of the Texas Code of Criminal Procedure. Is that correct, sir?
It is, Your Honor.
It is your motion. Please go ahead. please proceed.
And I'll go ahead and call Ms. Benavides, Your Honor, who's already been sworn in.
Okay,
Ms. Benavides, you entered into a deferred adjudication on the possession of marijuana back in December 10th, 2010. Are you that same Emilia Edith Benavides that did enter into the deferred adjudication?
Yes,
And did you successfully complete that deferred adjudication?
yes, I did.
When you filled out the admonishments and paperwork on that plea deal, did you, you had an attorney by the name of Mike Machado for that process?
Yes,
Were you admonished, or were you told the consequences it would have on you as it relates to you being a permanent resident at that time?
no,
And now that you've done this, you were presently facing deportation.
yes,
At that time, were you admonished, or were you aware that as a permanent resident, the deferred adjudication is considered by immigration as a final conviction? Were you aware of that?
no, sir.
Also, were you admonished, or were you aware that as a permanent resident, it really didn't affect you much at the time? The critical consequences, if you stepped out of the country or left the country and tried to come back in, that would make you deportable. Were you advised or admonished about that set of circumstances when you entered this agreement?
No,
And you departed the country to attend your, I think it was your grandmother's or relative funeral in Mexico in April, I think, what was the year?
2012.
2012.
Yes, sir.
And since then, you've been subject to deportation,
Yes,
and you're still awaiting that process.
yes,
And the reason for that is the agreement you entered for the deferred adjudication on this cause number 253857.
yes,
Knowing the consequences now, would you have entered such an agreement voluntarily, knowingly, and intelligently under the circumstances now?
no, no,
And did you enter such an agreement knowingly, voluntarily, intelligently back then?
no,
And you're presently asking the court to sign off on the agreed order on the writ of habeas corpus and set this aside?
yes, please.
Nothing further.
State, any questions?
No, Your Honor.
Counsel, please, your name again?
This is Fernando Cortez, Your Honor, and I apologize for not entering the retained counsel attorney record. I did do that yesterday. Again, I apologize for that.
So an attorney by the name of Mike Machado was the attorney of record at the time
That's correct, Your Honor.
for the criminal offense.
Yes, Your Honor.
And was he an immigration attorney?
No,
Did he give you an opportunity? Were you given an opportunity by the court or that attorney to consult with an immigration attorney?
no,
Were you advised that you needed to go ahead and consult with an immigration attorney?
no,
Did Mr. Attorney Machado go through with you as far as the immigration consequences?
no,
Did you on your own try to seek counsel or consultation regarding the immigration consequences of your plea?
not at that time, no.
Why not?
I didn't know that I would have any consequences leaving the country or signing for that matter. I was never asked if I was a citizen. I don't believe I was asked.
Be clear, you were not.
I was not asked.
You were not asked by the court whether you were a citizen of the United States.
Correct. Yes, that's why I did not seek immigration attorney at that time.
But you're saying that you were not asked by the court at that time whether you were a citizen or not?
Yes.
I would add, Your Honor, that the plea paperwork nowadays does include a section where the defendant is required to, and the attorney is required to acknowledge whether the person accepting a plea is a citizen or not. As you notice in the paperwork, that had not yet been included. And I think in 2010, that would have been at the beginning when they started giving this admonishment. It's just been an evolution of that issue.
Counsel, you entered this, you have this paperwork, you have some exhibits entered or attached as exhibits to your writ of habeas corpus?
That's correct, Your Honor.
Okay, this is your writ?
That's correct, Your Honor.
Okay. With attachments. I'm showing you a document that's entitled Course Admonitions and Defendant's Constitutional Waivers. I believe that's the title of the document. Would you look at the last paragraph there, please? Examine the last paragraph on the first page.
She's reviewed it, Your Honor.
And you have reviewed it, counsel?
I have, Your Honor.
Okay. And you have made a statement here. Did you wish to go ahead and add anything else, sir? Or modify anything that you've stated?
Only as it relates to, I certainly understand throughout these years that the issue of immigration has been an evolving process. Before this, there wasn't even that admonishment. A lot of times, counsel will present this to the defendant and just simply ask them to sign it. They usually cover the admonishments that relates to waiving a jury trial at the time. And I think that's why they now include, and I think this court is very particularly focused on the issue that an individual who is not a citizen, and now the paperwork has evolved to the point where it makes the attorney and defendant indicate whether they are or not. And the court is very careful to make sure that there is some type of consultation or acknowledgement on the record whether or not an attorney has been consulted, because of the critical and drastic consequences of signing such an agreement. I myself am a naturalized citizen and an immigrant, and there's no way anybody in their right mind would have entered such an agreement on the possession of marijuana deferred. No one would recommend such a thing, knowing the consequences. And even then, until I started investigating this, I was not aware that a permanent resident can accept this type of agreement and probably get a waiver, and it won't affect their citizenship as long as they don't leave the country. The minute they step out of the country, they instantly become deportable. And that's unfortunately what happened here. There should be a specific paragraph that relates to individuals, that language in this kind of admonishment, telling them not only that it could, but that it will. And even if it doesn't affect you now, if you're a permanent resident, step out of this country, you become deportable. It doesn't matter that it's deferred and it's dismissed afterward. The immigration considers it the final conviction and will deport you or begin deportation proceedings if you leave the country. She left the country for a funeral for her mom. And it's just devastating to me to think that even the way they do it now, the admonishment that forces an individual to acknowledge whether they're a citizen or not, should include other language that if you are a citizen, you just accept the deferred. It doesn't matter that if you step out of the country, the consequences will be drastic and severe and will result in your deportation. That should be included in here, even now, but it is not. Hopefully the evolution of this project continues to the point where it does do such a thing. I hope. But she absolutely was not aware of that. No one in their right mind would have signed such a thing. No one under those circumstances.
Counsel, some of the things that you have stated in here, as an immigrant myself, I understand your passion and I appreciate what you have stated with regard to that. And that is why you're right. Under this administration, I have always insisted at consultation with an qualified immigration attorney, and I write down the name at least, even I may have a Padilla letter or may not, but at least that they have consulted, and that is on the record, with an immigration attorney, just because of these consequences. I have run into it at the beginning of my administration. And so that has been a very, very, let's say, concern for me. The evolution includes the Padilla. However, counsel, with the CLEs, required CLE for counsels, for attorneys, there is a required CLE that's required concerning immigration consequences. And in light of, I believe it's Padilla versus Kentucky or some case of that nature. So counsel, the document, I handed you your habeas corpus, your writ, okay? And in this document, the defendant's waiver of constitutional rights and courts admonitions, would you agree that on paragraph 8, there is a warning? An admonishment regarding citizenship, at least citizenship of the United States?
I do agree that there's a very general admonishment at the bottom of that. Although the client was told that it would be dismissed, it was never discussed with her what the consequence would be to her status. I don't even know that was actually pointed out to her other than to sign the document and the general admonishments. I don't believe that she was actually told that. Even upon reading something and being told that it couldn't be dismissed, I think a reasonable person would infer that it would have no consequences. And I agree with the court, and I think the court is ahead of its time in that it would require certainly a letter or something indicating that a non-citizen has conferred with an immigration lawyer on that. That would at least cover any potential fact scenarios that are not indicated on there when a non-immigration lawyer admonishes an individual on general language and then indicating to that same individual that the case is dismissed. If somebody tells you something like that and it's dismissed, you would probably be reasonably inclined to believe, well, that's fine, and then not told specifically how it will affect you if you leave the country.
Counsel?
Yes,
your communication here is something of advocacy that would require future. There's nothing I can do about it regarding your writ at this time. I understand exactly what you're saying. I appreciate it. I am short on time. I'm going to take this into consideration, but I may need to go ahead and have you return in order for us to explore this matter and make sure that we have a good record of this issue, because you also are implying other things in your writ. Okay, that brings up other issues and possible sanctions or remedies. So we'll need to go ahead and give this the time that it deserves.
Yes,
And
Your
it's not at this time, okay?
Yes, Your Honor.
I appreciate it. So at this time, I will take it into consideration, and I'll have you and the DAs back here to be able to explore this a little bit more. Give me a minute to be able to consult with you on that.
Yes, Your
But
Honor.
at this time, I am going to need to allow you guys to give me a second.
Yes,
Okay, so I can deal with other issues,
Yes, Your Honor.
because I need to go ahead and shut down. My court reporter has to go.
Yes, Your Honor.
Okay,
Would you like it back at 1:15?
if you just give me a minute.
Yes, Your Honor.
Thank you.
Thank you.
If you step back, thank you.
Your Honor, I'd like to announce a resolution
yes.
in my case.
I understand. Please give me 2 seconds. Attorney Zimmerman? On the Chapco case, I am still waiting to see regarding a CLO, so a probation officer. So if you would, I'll probably need to go ahead and see you guys this afternoon.
Your Honor,
Okay.
it's Cielo de Santos. I'm here to cover.
Oh, there you are. Oh, okay. Thank you so much. All righty. Thank you. Okay. State, are you ready to go ahead and proceed on clause number 6344758?
One moment, Your Honor.
Who are you addressing, Judge?
The Chapco case?
Yes, okay, yes. We do have a offer from the state. I have not discussed it with the CLO, but we can go ahead and have the hearing right now, I guess.
Okay. Do you wish to go ahead and talk with the CLO about it? You're frozen, Mr. Attorney Zimmerman? You're frozen, Attorney Zimmerman? Looks frozen to me, right? Okay. Okay, I'm going to have to place the court in recess at until 1:15. I will deal with some of the matters that I have stated. But at this time, the court stands in recess until 1:15.
Judge, I don't need a record.
I understand. I will not be able to give you that at this time, sir. So 1:15.
No, I don't need a record. That's what I meant. I do not. I don't
Oh,
need a
you
court
do
record.
not?
No.
Yeah, that's not a problem. That's why I said I will go ahead and deal with those cases that.
Great.
I will deal with them, but
Okay.
I'm going to release her at this time.
Judge, I wasn't sure if you called my case for before lunch or after lunch, because I thought I heard the name Hawshaw, but my guy's Haw.
Oh, Crawshaw. Crawshaw is Attorney
Oh,
Crawshaw.
So
Yeah.
then I'm good till after lunch.
Yes, sir. Thank you. And excuse me, counsel, isn't that because you needed to, he just needed to show up?
Right.
Was there going to be anything on
Well, I'm
his
hoping
case?
we can clean him out today. It's okay if he's here in person and I do it on Zoom.
Oh, yeah, of course. You got the paperwork? Okay.
We should. We'll double check.
Okay. If you're on Zoom, you know it has to be electronic. Okay, all righty. State you'll need to go ahead and stay. You're not released yet. I just needed to release the court reporter.
I said.
Okay, Attorney Crawshaw, will, we can go ahead and hear your, and
Great.
we're recording, but
Thank
you
you, Judge.
give me 2 seconds. Attorney Munoz, I believe the same thing. And Attorney Zimmerman, you're conferring with us, the CLO or not?
Whatever the court desires.
I mean, you're not, obviously not in there. Have you been sent?
My
you received any
Wi-Fi was disconnected and I am now back online, Judge, in Zoom, obviously. So I guess, yeah, I would like to speak to the CLO. Obviously, I don't think we can have a hearing if your court reporter is going to be absent for a while. So maybe we can have the hearing this afternoon.
Absolutely, sir. Let's go ahead and get everything done that we can, okay? Since folks are here already. So let me go ahead and put you in with Taya Santos, CLO's Taya Santos. Okay,
Okay, thank you, Judge.
thank you. Wait a minute, who did okay. All righty, all righty. I'm going to need my court reporter for your case, sir. So 1:15. It's a motion.
You're on Zoom, Judge, at 1:15?
Of course, yes, you can appear by Zoom.
Your Honor, am I okay to leave till 1:15?
Yes, you need to be back at 1:15, Mr. Ramirez.
Okay.
Thank you. All right.
Thank you.
Okay, let me go ahead and cross. Attorney Munoz. Remind me of your case again?
Yes, it's Charlie Hayworth. The state has filed a motion to dismiss. I think the newest one should be in your inbox. They're dismissing for insufficient evidence.
Thank you. I don't want to be sure, but I need for it to be concise. So, Mr. De Leon, is that David De Leon?
Yes, Your Honor.
Okay, we have been trying to contact your attorney. And so I don't know what the procedures are, but you'll need to be back at 1:15. Did you have an officer there that I need to speak with?
Let me see, Your Honor.
Okay.
Judge,
At the same will.
type in your email as well. This is in regards to Mr. De Leon.
And Judge, I just need to announce I have a pretrial diversion application. We need to get started or get a comeback date.
Got you, sir. I understand. I'm going through. I will address your issue. Attorney Zimmerman and Chapco as well. There's an officer that just walked past. Okay.
Hey, Judge, did you need something?
Yes, I do. I need Mr. Chapco back at, and Mr. De Leon, David De Leon back at 1:15. Would that be possible, sir?
No problem. We'll take care of it.
Thank you very much. I appreciate it.
Yes,
Very
ma'am.
kind. Now, Sydney Christian,
That's my client, Judge.
whose client? Okay,
Adam
that's
Crawshaw's.
thank you. Okay. Bobby De Leon. Who's your attorney, Mr. De Leon?
Hi, Your Honor. Good afternoon, Your Honor. This is Attorney Javier Garcia.
Okay, 1:15, sir, with your client. 1:15, please. Thank you.
Thank you, Your Honor.
Okay, I think that addresses everybody, takes care of everybody that needs to be. State and Attorney Cortez.
Yes, Your Honor.
Just attorneys,
Yes, Your
please approach.
Judge, if I may interrupt just momentarily, this is Ron Zimmerman. You want me back at 1:15 this afternoon, Judge?
Yes, sir. I've already arranged for your client to be back at 1:15, sir.
Yeah, I saw that, Judge. I thank you for that consideration, and I will be back at 1:15 then, Judge.
See you then. Thank you for
All
your
right.
patience in working this. Okay. I think you can appreciate the implications involved here. And so I believe that we need to, I didn't see a transcript.
The problem with that, Your Honor, and I tried to obtain the transcript on that, and there is no transcript for that date. I had to go through two court reporters, the one before that, and then the one from 2010. And I would advise that there is no transcript on this matter. There isn't. Unfortunately, that's the first thing I tried to get, obviously. There isn't even a transcript on it.
Alrighty. Counsel, let me take a look at it.
Yes, Your Honor.
Is this something that we'll be able to go ahead and address? What's your schedule look like? Would you go ahead and take a look
Whatever
at
the
your
court
schedule?
wants, I'll be here.
Alrighty. Let me look at my schedule.
Yes, Your Honor.
Okay. And
I don't know if it wants me to do anything on the transcript issue. I spoke to the previous court reporter. I have an email from her telling me who to contact. But I only spoke to the previous one that was here at the time for, I guess, Judge Nelson Wolf, and she's the one that advised me that there was no transcript on this matter. And I also have the immigration lawyer, Rocio Ramirez, was available. She's sick today, but she would be available by Zoom. The court needs to talk to her on the consequences here. I didn't get a return call on Mr. Machado on this, and it is generally a very difficult thing to get an attorney to acknowledge certain types of areas.
let me go ahead and get your info,
Yes, Your
just for convenience sake, right there. Oh, okay. Sorry. I'm smiling because I believe your habeas is quite involved. And the only thing that you have is
the order I was told by the immigration lawyer, which is another issue I would like to note to the court, that if the language is not the way it is right there, and there's different language, it is then still unacceptable to the immigration department. So even if the court granted this motion without that language on there, it's still worthless. How many people could even begin to understand the complexity of this? It's just too far-fetched. Like I said, the court is way ahead of itself in the admonishment that it gives. Unfortunately, not everybody is doing it. And I think there's still a further evolution that should be required on these admonishments, unfortunately.
counsel, this deserves a review.
Yes, sir.
You understand? Okay. A thorough review. You didn't put a phone number down?
No.
Phone number?
Yes, sir.
And so I would like to be able to give this the thoroughness that it deserves. And so let me give you a call and coordinate something with you and the state. At this time, that conversation, we don't need to have your client here.
Yes, Your Honor.
But right now, let me just go ahead and sort something out.
Yes, Your Honor.
I'll give you guys a call to come talk to me.
Yes, Your Honor.
Then we'll set up a time to have a thorough review of this.
Yes, Your Honor.
Does that
Yes.
sound like a plan?
Yes, Your Honor, absolutely.
All right.
Excuse you, Your Honor.
Yes, sure. Thank you.
So much.
Okay, be by your phone. We'll get it.
Clarification. Thank you, Judge.
Okay, thank you.
Judge, is that for me? Should I just come back to 115 or anything else?
There's a couple of cases right here. I wanted to see if I can address, since whatever I needed to do. Okay. Okay, so the only two cases I'm going to go ahead and address at this time, since state, so as to get you out of here, are the Sydney Christian case.
Yes, Judge.
You're off docket matter?
Yeah.
Or will you recall for today, sir?
A little bit of both, actually, if you don't mind me saying that. I'm trying to be helpful to the court.
Of course.
And to me. I have been working very hard on this case, and the state's extended a pretrial diversion offer, and we want to take it. And so I just
give me the case number, sir.
682030.
Okay, let me see if I have it. One more time.
Sure, 682030. And basically, Judge, all we need is a date to come back to check in on the pretrial diversion status. I just need your permission to get that date from Miss Luna.
Okay, so on this matter, counsel, did you give me a brief? Court is going to call cause number 682030, State of Texas versus Sydney Christian. We are going to proceed an electronic audio record of this matter. Counsel, do you have a problem with that? Do you have any objections?
No, Judge, thank you.
State, do you have any objections? All right, proceed. Councils, parties, please approach and identify who's before the court.
Victor Hernandez for the state.
Adam Crawshaw from Miss Christian. Miss Christian,
And-
you can say hi.
Hello.
And Sydney Christian, let the record reflect that the defendant is in this court session with her attorney. Counsel, if you wish to go ahead, I do and don't have the file on this. Did you want to go ahead and provide a brief
Judge, that
background
have
to
to
this
be on
matter,
your
where
pen.
we're at?
Judge, yeah, all we need, Judge, is your permission to get a check-in date to come back via Zoom to make sure that the pretrial diversion application has been completed.
Yeah. This matter was set for trial, correct?
Yes, it's on call. I don't think we're going to be reached because, and I got with the state this morning and I have felony. Anyway, we've got it resolved without the necessity of trial. And that's what we'd like to do. And I just need to do that.
Okay, so you reach a resolution that will not involve trial.
Yes, yes.
All right, state, what is the resolution?
As I understand, the defendant will enter pretrial diversion. Looks like it'll be for 18 months with an anger management course and counseling services during the duration of the pretrial diversion period.
So state you found this defendant and this case to be eligible for pretrial diversion.
Well, Your Honor, I don't see any specific note about that. Looks like we did recommend and agree to that though. So I mean, unless there's some other finding that she's ineligible, the state will agree that the defendant will enter that program.
Well, you found it to be eligible for pretrial diversion is the question.
Yes, they did. It was Ms. Hahn that did. I have her email in front of me.
Oh, yes, right.
Okay. State in doing so, what type of case is this? What's the offense?
This case involves harassment, Your Honor.
And counsel, when have you applied for the pretrial diversion?
No, Judge, that's what I've been asking to get a check-in date to come back to do that. I can have that application done by Monday. Ms. Christian's very prompt.
Okay.
Monday or Tuesday, but I just need a check-in date. I don't know how long it's going to take me to get a copy of that pre-TD application.
How long it's going to take you to get the application or to be able to have it processed?
Well, I don't know how long they're going to take to process it, but we can complete it very quickly.
Okay, so you're going to apply at least by Monday or Tuesday, sir?
Yeah, can we say it'll be by Wednesday just to be safe?
Okay.
And we'll get that submitted to the state.
And state, it's taking about how long to go ahead and get the processing done?
Well, I don't know, I'm not sure about that exactly. From what I understood, it could take a matter of months from what I understood. But I don't have the information in front of me.
It may go much quicker than that. This is not a complicated case.
Council, look at your calendar.
Yes, I'm looking at it now.
All righty, and the date that you're looking for in order to have the pre-trial diversion process completed in this court to receive a pre-trial diversion dismissal. I think they have stated about 3 or 4 months.
Okay.
Because, there's just so many applications and holidays and things like that.
I can reset it to, Miss Luna. Can
Sir, if you check your calendar,
Yes, I'm looking at it now, Judge.
3-4 months date.
Okay. Can we do? What about Monday, March 6th?
Okay, did you want to drop it down a little bit more just to be safe, the 31st of March?
Oh, that'll be fine.
All righty, okay. As you stated, counsel, you have worked very diligently and very hard on this case in order to be able to bring it to a resolution. And I appreciate your efforts very much and your advocacy for your client. It's always a pleasure. If you would please be able to go into the breakout room and get a case reset form for the 31st of March, 2022 for pre-trial diversion purposes.
Will do, Judge. I have one more case off docket that I'm going to come back on at 1 o'clock.
Okay, 1:15, sir.
Oh, I'll do that. I'll see you in 1:15.
All righty. Look forward to seeing you then, counsel.
Thank you.
Attorney,
Christian, we're going to be assigned to a breakout room.
we are off record on this matter and oh, okay. There you go, counsel. I believe she's got her invitation and you have your invitation. You went to the same room, didn't you? You have the invitation? Okay, great. Attorney Munoz, cause number, please.
102, no, sorry, 629-731.
Okay, council, I have not received the dismissal from the state, a retuned dismissal from the state on this matter. I see the explanation. I see the communication, your responses. And so I think that they, for the paperwork to reflect for perpetuity, that it should reflect the accuracy of the reason for the dismissal. Do you agree, Counselor?
Yes, Your Honor, I agree. And I believe I received an updated copy that states that they're dismissing for insufficient evidence. I believe.
Oh, I haven't seen it. I
Yeah, I
haven't
don't
seen
know if is Ms. Hahn on right now or.
Attorney ADA Victor Hernandez.
Okay.
Yes, Your Honor, looks like it went out. Let me see what happened here.
Okay. I'm trying to check on, click on everything that I see with that case number. Let's see.
I don't know if I can forward it. I think it has to come through.
Everything that I'm clicking on that says review and sign is coming up already processed. So.
Okay.
Okay. So let me take a look at the.
Well, I guess, Your Honor, is it possible that I be excused, I guess, from this setting with the fact that it is going to be dismissed?
Well, let's go ahead and let's absolutely. I think that we are all in communication. Otherwise, if there's an issue, you'll definitely be included and know. Okay. But right now, yes, sir, Counsel, you're excused. I appreciate your advocacy on this matter.
Thank you, Your Honor.
Thank you. Alrighty. We're done until 1:15. Attorney Crenshaw, the state needs to go ahead and take a break. And so does my deputy.
I understand, Judge. I just wanted to ask the court a question.
Okay, please.
I have a case that's set next week and there's a felony pending. Can I get a new date for that? Because that felony is not going to be resolved at the next setting.
Sounds like that's something that we can discuss at 1:15 if you
Okay,
approach
I just
on
wanted to see if I could do it sooner than that. That's all. I'll be back at 1:15.
Okay, well, call the court, make sure that we have I have the file, if you would, okay?
Yes, very good.
Thank you. Have a
Thank
good
you.
one.
You too.
Leon is on here. State, do you have clause number 634-758, 682-226, and then 674-527?
I still have them up here, Judge. Yes.
Okay, the priority this afternoon, the order I will proceed in, thus so far, just to get at these cases, is I'll take up the matter of cause number 634-758 on Chapco. And then on De Leon, 682-226 on David De Leon, as they are both in custody. Then next would be cause number 678-644 under Michael Ramirez, and then 674-527 Bobby De Leon Jr., and then 680-954. That's how we will be able to handle that thus so far. Attorney Goins, thank you for jumping on. Do you need to confer with the ADAs?
I don't believe so, Your Honor. We've got a indicted felony we're waiting for a trial date on. And they all the two felonies and the misdemeanors run out of the same occurrence.
And you are the attorney on both, sir?
I'm the attorney on all of them. Last trial day we had set was August the 2nd, which was in concert with your court also. And we've not got a new trial date for the felony court at this time.
And the matter is going to be via, let me get this.
And I have the cause number if you need it, Your Honor.
Okay, I'm finding it. 144. Sir, what's your calendar look like? You don't have a date on the pending case?
No, we do not, Your Honor. The judge in the 144th has not done anything since about the end of October.
Council, just quickly go ahead and look at your March calendar.
Your Honor, if you want to do it in March, we'll fit it in sometime in there, anywhere you want to go. I don't have much on there as of yet.
Well, I'm sorry, I said March, but what's your calendar look like, sir?
Your Honor, everything's going to start back up again in January, probably for the 144th. I don't have anything scheduled on 144th for the month of December.
What's your calendar look like, sir, for next year, for this case, if you want it to be set the same?
Can we get it set for the end of January?
Okay. Looking at your calendar, sir?
Anytime at the end of January, Your Honor.
Okay, hold on. All right, council. Dennis, can I record? Okay, you ready on class number 634758?
You said 634758? Yes, Your Honor, I have that up. Yeah.
You have the microphone?
Yes, Your Honor, I have it here.
Judge, do you want Mr. De Leon and Mr. Goins to come back and announce the date? I think your microphone might be off there.
They can be excused from there.
Okay, thank you.
Let us get on record on cause number 634-758, State of Texas versus Paul Wayne Chapko. Parties, please approach and identify who's before the court, starting with the state.
Victor Hernandez for the state.
Defense.
Yes, Ron Zimmerman for defense, Your Honor. If I may, if we could go off the record for a little bit, I need to conference with Mr. Chopko in a breakout room, if I may, Judge.
Off the record, place Mr. Chapko and Attorney Zimmerman in a breakout room. All right, let's get on record on cause number 678-644, State of Texas versus Michael Ramirez. Parties, please approach and identify who's before the court, starting with the state.
Victor Hernandez for the state.
Tom Nisbet on behalf of Mr. Ramirez.
Mr. Ramirez, please mute and respond so the court may recognize you.
Here, Your Honor.
Let the record reflect that the defendant is in the court session with his attorney. And we are here, counsel, you and the state had put in a motion for continuance. This matter was set for trial for the 5th of Monday, the 5th of December, correct? So far, counsel, that's your understanding?
Which counsel, Judge, state or defense? Or any?
I address the state as state counsel.
Yes, Judge, that is a correct fact. Yes, sir.
And state, that's your understanding?
Yes, Your Honor.
All righty, so that matter was set and both of you tendered a motions for continuance. Separately and unopposed to each other, correct? State?
Yes, Your Honor.
Defense?
Yes.
Alrighty, and the court, your detailed motion for continuance, counsel, indicated there are certain witnesses or identified certain officers that needed to produce some information. The material witnesses, I believe, is your verbiage on the motions for count, on your motion for continuance. Is that correct?
Yes.
Okay, and then the court ordered the state to have those officers be able to appear to see what the issues are regarding their ability to produce the discovery material that is material to this case and being able to go ahead and produce that item. Is that correct, state?
Yes, Your Honor. I think it's specifically for San Antonio Police Officer Waclazic. Yes, Your Honor.
All righty, state, proceed. What happened?
Your Honor, the state has decided to move to dismiss the case this time and will not proceed with prosecution, Your Honor.
The state will not pursue prosecution of this case at all?
Well, Your Honor, at this time, as I understand, the state may have the ability to refile later, but at this point, the state is dismissing for a further investigation, as the state's motion to dismiss says, Your Honor.
And further investigation as to what? As to the appearance or availability of this officer, the missing information?
There are numerous possibilities. It could be relating to the video from the San Antonio police officer, but however, regardless, the state has just decided not to proceed at this time.
You're not able to locate this witness or the material?
Oh, well, Your Honor, we did have contact with the police officer. However, the state just decided at this time to not to proceed with the case.
So you do have contact with the police officer?
Yes, Your Honor.
And is the police officer refusing to produce the material?
No, Your Honor. In fact, my discussion or interaction with the police officer this morning, she said that that would most likely be available under the San Antonio Police Department report number. And so the state can look further into that if we decide to proceed with prosecution of that, Your Honor.
When will you be able to go ahead and acquire that? Because that seems to be the materiality of this matter. That is the crux of the motion for continuance, and you are agreed and unopposed to that motion for continuance. When would that be ready?
Your Honor, I'm not sure if I can predict that, especially since the state has decided to dismiss the case. We have not taken any efforts to further investigate any time for availability of that evidence, Your Honor.
You have submitted a motion to dismiss, to move this court to dismiss this case. And this court is wanting to be convinced of, to be moved to dismiss this case for further investigation. State?
Well, Your Honor, it looks like a sheriff's deputy that was in the case did not appear for an appointment with the state to discuss the case, and so the state wishes to also dismiss to see if we can get a hold of that witness, and that was the primary officer in that case. So because of that, it looks like the state needs to further investigate that, Your Honor.
Which officer is that you're referring to?
Oh, that's Deputy Brent Bible, Your Honor.
So Deputy Bible is not available or refusing to cooperate with the state? Which one is it?
Your Honor, I'm not sure if either of those apply at this time, but for one reason or another, just which I cannot speculate on, he just did not show up to an appointment that the state requested for him to show up in our office this morning. And so without any further information as to his unavailability, I'm not going to speculate on his possible refusal or any other reason, Your Honor.
So the appointment was for this morning?
Yes, Your Honor.
This case will be recalled for Tuesday, the 6th of December, for you to go ahead and make further efforts to get hold of those officers and the information. At that time, please advise this court on Monday and see see what we can be able to assist you with if you're not able to get a hold of those officers.
I can do it. Yes, Your Honor.
All righty. Counsel put you in the breakout room for you to receive a case setting form for Tuesday, the 6th of December.
Does my client proceed to the breakout room, Your Honor, or may he be excused?
Yes, he can go ahead and go into the breakout room with you, sir. And you guys are excused from there. Have a good weekend.
And you look very nice in your coat and tie.
Nisbet's case. So, did you get dismissal?
ADA Lin Han,
Yes, Judge.
please join me in the breakout room with Attorney Strickland.
Okay.
You as well, court reporter. I think I need to send you an invite. No. Okay. Okay, 9. Ms. Anderson, I'll need for you to go ahead and accept the invitation I just sent you. Do you see it? Okay. Do you see it?
Clear all that up.
Okay, still on the record. Counsel, were you able to explain to your client the issue of why the court recalled her?
I did, Judge, and I'll let her know that I'll help her get prepared with that to the court.
We can return to the main session. And Ms. Anderson, get a hold of your attorney, you're free to leave, okay? Yes.
On this one, do you reply for Tuesday? Are you replying to the trial or just agreeing?
Just put a waiting trial. And there's going to be a status.
Status, right?
Yes. But a waiting trial. Attorney Zimmerman, are you ready? Sorry.
Yes, Judge.
Are you ready to proceed?
Yes, we are, Judge.
All righty. Let us get on. State, are you ready to proceed on the MTR case? Okay, let us get on record and on cause number 634-758, State of Texas versus Paul Wayne Chapko. Parties, please approach and identify who's before the court, starting with the state.
Victor Hernandez for the state.
And Ron Zimmerman for the defense for Mr. Chapko.
And are you Paul Wayne Chapko? Please unmute and respond.
Yes, Your Honor.
Are you the same Paul Wayne Chapko that was placed on probation on the 18th day of December 2021 for driving while intoxicated and for 10 months? Are you the same Paul Wayne Chapko?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth under pains and penalties of perjury, so help you God?
Yes, I do.
Thank you very much. You may go ahead and lower your hand. Counsel, how long have you been representing Mr. Chapko?
More than 10 days, Your Honor, approximately 2 months.
And do you believe that your client is competent to proceed?
I believe so, Judge.
State, which violations are you proceeding with?
Currently, the state is only proceeding on violation number 4. And waiving and amending the others.
You'll be proceeding on violation number 4 and waiving all the other violations?
Yes, Your Honor.
Alrighty, please proceed.
Your Honor, violation number 4 specifies that the defendant in Bear County, Texas, the defendant Paul Wayne Chapco Dindanair failed to report to the supervision officer as directed for the month of August and September 2022 in violation of condition number 4.
Mr. Chapko, how do you plead to that? True or not true?
True, Your Honor.
And now, the probationer having pled true, Officer Tellez, sorry, CLO, you announced, sorry, could you please re-announce Officer Tellez Santos?
Yes, Judge, it's CLO Tellez Santos covering for CLO Jennings.
Okay. And what are the course options at this time?
Your Honor, probation is recommending to extend for 1 year and to order SATF, followed by aftercare. Probationer to remain in custody until SATF that it's available. And to lastly, satisfy condition of in-home device once probationer is in residential treatment.
Officer Tellez Santos, the course option is to be able to either continue this probationer on probation, revoke his community supervision, or deny the MTR and continue on probation, correct?
Yes, Judge.
He's not here. He is here on an adjudicated matter. Therefore, he has a red conviction, correct?
Yes, Judge.
Okay. Mr. Chapko, knowing, understanding the course options in this matter, do you still wish to plead true?
Yes, Your Honor.
All righty. State what are your recommendation to the court?
As I understand, the state recommends the defendant continue on supervision without any additional requirements except for zero tolerance.
Judge?
2 seconds, please.
Okay.
Continue on probation
Yes, Your Honor, I think it's what my notes say here.
with zero tolerance.
Yes, Your Honor.
Okay.
I think we might have discussed with defense counsel. I don't know if you can elaborate.
Yes, Judge. I don't believe that was the agreement for the recommendation, Judge. If I may have if we may go off the record and if I may have a breakout with the state to help resolve this discrepancy.
Okay.
I'm sorry, Your Honor, as I understand, it might not be necessary. As I understand, I might have read too late in the notes. From what I see, it looks like it's 28 days in the Bear County Jail, Your Honor. I'm not sure if defense can confirm that.
Yes, I can confirm that the agreed recommendation to the court was 28 days revocation with 28 days, or reform the judgment to 28 days Bear County Jail.
And so, counsel, that is your understanding.
Yes, it is, Judge.
And Mr. Chapko, is that your understanding?
Yes, Your Honor.
Okay. And CLO, how has Mr. Chapko been doing while on probation?
Judge, he has not satisfied all his conditions. he has failed to complete the U-Impact, the DWI intervention, has failed to provide verification of attendance to SOVR support meetings, failed to provide proof of 5 job searches per week, failed to complete 30 hours of community service, and has a remaining balance of $6,702.
Was he being monitored?
Your Honor, it appears that his last office visit was on August 18, 2022.
His last what?
Office visit,
Mhm.
he last reported on or about August 18, 2022.
Was he being monitored on a monitoring device for alcohol that?
I'm sorry, Judge, it looks like, I'm sorry, Your Honor, I would have to check on that. It looks like he had the portable alcohol monitor device.
And what, how has he performed with that?
I'm checking his file, Your Honor. It appears that he obtained the in-home device on February 7, 2022. And since then, he had 123 pass tests, 204 skip tests, and no hybrax.
UAs?
His last UA, Your Honor, was July 25th, 2022. I'm sorry, he last failed to submit a drug test on July 25th, 2022. While on probation, he submitted to 2 drug tests, one on January 31st, 2022. He tested negative. Second drug test, it's March 28th, 2022, and he tested negative. He has 5 failed to submit.
And what are the dates of that one? You've already provided 7 February 2022. What are the dates for the others?
For the fail to submit, Your Honor, it is February 25th, 2022, March 22nd, 2022, May 2nd, 2022, May 6th, 2022, lastly, July 25th, 2022.
How frequently was he supposed to submit? What was the frequency? Every 2 weeks, monthly?
Judge, 1 second, I have to check on that. He was ordered to submit to monthly UAs and to include ETS and ETG. for his duration of probation.
Counsel, what do you have, excuse me, and probation, what is your recommendation?
Yes, Judge. Probation's recommendation is to extend for 1 year and to order SATF followed by aftercare. Probationer to remain in custody until SATF bed is available and to satisfy condition of in-home device once he is in residential treatment.
And regarding, just to go back on the in-home device, it was an in-home device, and you said the last time that he used it was the 7th of February, 2022, or please refresh. Oh, no, you said that's when he installed it.
Yes, Your
and
Honor.
I know it's now, okay. Counsel, what do you have on behalf of your client?
Yes, Judge. Mr. Chopko has had a fairly difficult year, Judge. He is somewhat homeless. His cousin, she has agreed to allow him to reside at her residence. But from what Mr. Chopko tells me, that residence is out of town, out in the country, and he does not have transportation. So it has been very difficult for him to be employed and to make appointments requiring his physical presence, in that he doesn't have the ability to attain transportation to be at the physical place where he's required to be. And that has greatly hampered his ability to fulfill the requirements of his probation. He has expressed to me regret for that. And he also has expressed to me that he does want to pay his debt. And that's why he instructed me to go ahead and seek an agreement with the state in order for him to serve out his sentence in Bexar County Jail, and to negotiate with the state the amount of time that the state would recommend. And we did reach that agreement, Your Honor. The state has recommended that he be sentenced, and that the sentence be reformed to 28 days to be served in the Bexar County Jail, Judge. We would request from the court that the court follow the recommendation of the state and allow Mr. Chopko to fulfill that obligation to the court and serve the 28 days in Bear County Jail, in which he'll be obviously deprived of his liberty at that time.
So you know how many days that he has to his credit?
I'm not sure the exact days. I spoke to your coordinator yesterday. I think she told me that Mr. Chopko has 6 days. 5 or 6 days.
Please address the portable alcohol monitoring device. What were the issues with these 204 skips?
204 skipped. Your Honor, I don't have an absolute idea exactly why on that number of 204 skipped. Mr. Chopko has had difficulties in maintaining his requirements on the supervision of the court outside of jail, which is why he's requested that he be allowed to fulfill his obligation to the court by remaining in Bear County Jail, deprived of his liberty for the 28 days, Judge.
You probably could appreciate the probation's recommendation concerning SADF. Did you wish to go ahead and address that?
SADF, yeah, Judge, I just don't know how well Mr. Chopko will do in SADF, Judge. I'm not sure that that's actually appropriate for Mr. Chopko at this time. Again, it is a restriction of his liberty, and he has expressed that it will be difficult to go in and do UAs once he's released, in that he will be, as of now, be staying with his cousin in her house, which is out in the country. So it may be difficult if he is sent to SADF for him to fulfill any aftercare requirements. And of course, that will put him right back into this court, Judge. And so he desires to remain in Bear County Jail, as I said, deprived of his liberty, and that the court follow the 28 days agreed upon by the state.
State, this appeared to be an allegation charged as initially as a DWI second offense. It was, I guess, negotiated and pled down to a DWI first offense. What has been the prior cases, or has there been prior cases on this matter and for Mr. Chopko?
Oh, 1 moment, Your Honor. Let me see if I can find information on that. Looks like there was a prior case for the conviction in November of 2014. The prior offense, Your Honor.
That was a conviction?
Yes, Your Honor. That's what I'm seeing here in the information for the present charge. It was cause number 449629. I can look into the specifics of what happened there.
There are no other prior alcohol-related offenses?
No, Your Honor, there's nothing I see here.
Defense, if you would like to be able to talk to your client, I will give you that opportunity at this time because what the court, he can either do 6 months with treatment or he can do 6 months without treatment. Or he can at least get some treatment within the jail as far as the court will order that he participates in sober support meetings while in the jail and any other treatment resources that's available in the jail. So he can do it in jail and avail himself to treatment there, or he can avail himself to treatment at SADF. Would you like to speak with an opportunity to speak with your client?
Yes, Judge, if I may.
All right. We'll suspend this record at this time. Attorney for Bobby De Leon, counsel.
Hi, good afternoon, Your Honor.
Good afternoon. Counsel, do you have a separate personnel data sheet that you need to send to me? Because this one is incomplete.
Yes, Your Honor, I apologize. I actually sent two, but the most recent one should be the most correct one, Your Honor.
Oh, okay. Okay.
It should have my handwritten signature as well as and I sent it to Marina, Your Honor. I apologize, Miss Luna.
Okay. Okay.
And the first one you submitted is one. Here you can just the bottom.
Okay, thank you.
And Your Honor, just to advise the court, it should be complete. It should have his license plate number to his truck. That would be the most recent, correct?
That's the one, that's the recent?
Yes, Your Honor.
Okay. Let us get on record on cause number 674-527, State of Texas versus Bobby De Leon Jr. The court calls that matter to the bar. Parties, please approach and identify who's before the court on this matter, starting with the state.
Victor Hernandez for the state.
You got to see it from Mr. Bobby De Leon Jr., Your Honor, and I'm Mr. Shannon Locke's associate attorney, one of them.
And are you Bobby De Leon Jr.?
Yes, I am.
Are you the same Bobby De Leon Bobby De Leon Jr., who has been accused of discharging a firearm in the municipality population greater than 100,000, alleged to have occurred on the 27th of November, 2021, and classified as a Class A misdemeanor? Are you the same so accused?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth under pains and penalties of perjury, so help you God?
Yes, Your Honor.
You may go ahead and lower your hand. The defense is on Zoom and the state is in the courtroom. Therefore, we're operating hybrid. And the court is going to start sharing the court screen. Mr. De Leon, can you see the court screen?
Yes, Your Honor.
And counsel?
Yes, Your Honor.
State?
Yes, Your Honor.
State on display is a document entitled State's Consent to Video Conferencing. Did you sign that document that's consenting to these proceedings by video conferencing?
No, Your Honor, Assistant District Attorney Ling Han signed it, but the state adopts it.
State's video conferencing consent is made part of the record. Defense on display is a document entitled Defendant's Consent to Video Conferencing. Mr. De Leon, is this your signature where the court is circling the cursor?
Yes.
Did you sign this document that's consenting to plea by video conferencing?
Yes, Your Honor.
And counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
Yes, Your Honor.
The defendant's video conferencing consent is made part of the record. Counsel, how long have you represented Mr. De Leon?
This is approximately the time of the offense, Your Honor, maybe about a year, Your Honor.
And are we applying for probation? And if so, what type?
We're applying, yes, Your Honor, we're applying for deferred adjudication, Your Honor.
Mr. De Leon, I draw your attention to the document on display. It's entitled Application for Deferred Adjudication Community Supervision. This is your application. It's a 2-page document. This is the first page. This is the second page. I draw your attention to where I am circling the cursor right about at the middle of the second page. It states that you personally appeared before me today, albeit via Zoom, that you are the defendant in this case, and I have sworn you in. Under oath, you're telling me that your application for deferred adjudication community supervision and the document entitled your personal data sheet, which is going to be attached as an exhibit to your application, is true and correct. Mr. De Leon, is that true and correct?
Yes, Your Honor.
Righty. So your application as well as the personal data sheet is true.
Yes.
Now, sir, do you need to talk with your attorney before responding to this statement to understand the consequences of your response to this statement, that the defendant understands and acknowledges that any untrue statement in your application or your personal data sheet may be grounds for denial or revocation of your community supervision in this case? Do you need to speak with your attorney?
Like references, I had the 3 references that I fixed on that application, and they resent it, so everything should be correct.
Okay, so the question is, do you need to speak with your attorney to understand the consequences of your response? Do you want to? Okay, we'll suspend the record so that you may go ahead and have the opportunity to do that and go over the material. Suspend the record and place the defendant in the breakout room with his attorney. You ready? Esther? You ready? Let's get back on cause number 634758, State of Texas versus Paul Wayne Shapko. At the time that we suspended the record, counsel, the court had court had asked you whether you wanted to go ahead and speak with your client. Oh, excuse me, let me stop sharing my screen. Counsel, are you ready to proceed?
Yes, Judge, we're ready to proceed. I've got a couple of questions, though, given the parameters of the thinking or the opinion of the court. You had expressed that he could receive treatment through a treatment facility, SATF, or that he could receive treatment while he's in Bexar County Jail. Is that correct, Judge?
Yes, sir. They do have, I think, sober support meetings there, and there may be some other treatment. I know that they had a worse program there, but I don't think that's operating any longer, but I'm not sure. So whatever treatment the court would order him to avail himself to any and all treatments that's offered.
Yes. Judge, if he were to have his probation revoked and sentenced as you had previously, or the court had previously mentioned, to 6 months in Bear County Jail, and he would receive treatment in the Bear County Jail while he is serving his sentence, that treatment would expire on the day that he is released. Is that correct, Judge?
The treatment requirement,
Well, if he's revoked, Judge, then once he's released, he has served his sentence, and then he would not have any further requirements of treatment by the court or any other obligation to the court, Judge. Is that correct?
except for the fees, I believe that's contains restitution. How miscellaneous fees. Officer Telios, is that correct?
Your Honor, the fees do not include restitution.
They do not include miscellaneous traffic fees or fine?
No, Your Honor, they do include a court cost of $6,000.
So, counsel, there would be a requirement to be able to deal with that matter, because
Okay, Judge, if he was revoked, the court would grant him credit for time served and time and money to run concurrent at that time, right, Judge?
sir, that's something regarding the restitution. As you understand, restitution it does not contemplate a time and money to run concurrent with regard to that restitution.
Okay, so the court is under the, has taken the position that he would still owe the approximately $7,000
I believe
once released from Bear County Jail?
Unless counsel, you have some other information that you can be able to, that this is what my understanding is, but if you have any other information, the court will definitely be glad to consider it. I was just offering that as a point of consideration.
Thank you, Judge. Well, if he did receive revocation and was sentenced to the underlying time of 180 days in Bear County Jail, then at that point, he would, after he fulfilled his obligation as far as the sentence is concerned of incarceration, he would still owe monies.
Counsel, that you can go ahead and explore that and be able to bring that to the court's attention. I offered for you to be able to go ahead and take a look at that, consider that, take that into consideration. Do you wish to continue to speak with your client? You want to look into that matter? Which one would you like to do?
I would like to look into that matter, Judge, whether he actually still would owe any restitution amount, and that is to the court, Judge.
I will have you go with the CLO. She can pull up the actual judgment.
Okay. And
you can also call the clerks, have them look at exactly what was stated as far as the judgment is concerned, be able to identify those fees. She can break down those fees for you, and so that you have an opportunity to take a look at it. And then I refer you to the Texas Code of Criminal Procedure, I believe, or the traffic, section 709. So, and it may be in it, but I'll let you do that. Okay.
All right, Judge. Yes, I will need a little bit of time to consider that. I would like to speak to the CLO, if I may, Judge, and find out what the exact figure is as far as any restitutional matters are concerned, Judge.
Okay, sir. Let's go ahead and suspend the record again and place the Attorney Zimmerman with the CLO, please. Esther, you ready? Okay. Let us get back on record on cause number 674-527, State of Texas versus Bobby De Leon Jr. At the time that we suspended the record, I believe the defendant wished to go ahead and speak with his attorney. Defense, are we ready to proceed?
Yes, Your Honor, we are.
State, are you ready to proceed?
Yes, Your Honor.
Court is going to start sharing the court screen again. At the time that we suspended the record, the court had asked the defendant if he wished to speak with his attorney to understand the consequences of his response to the statement, whether the defendant understood and acknowledged that any untrue statement in his application or the personal data sheet may be grounds for denial or revocation of any community supervision in this case. Mr. De Leon, what is your response to that?
Everything on there is correct. I was just concerned about an address.
Okay, sir, do you understand? Mr. De Leon, please respond audibly so I can hear you. Do you understand?
Yes, Your Honor.
And do you acknowledge?
Yes.
Counsel, do you have anything to add for the benefit of the court or the client?
Yes, Your Honor, just real quick, our client just wanted to, he stated the address is to the best of his knowledge, Your Honor. He's not making any intentional misrepresentations on that. That was his concern, Your Honor.
As the address is regarding what, his address or?
My mom.
As his references, his 3 references, Your Honor. But that's all as far as everything else, the contents are true.
Mr. De Leon, I appreciate your conscientiousness. And when you come in to provide your fingerprints, you'll be able to go and make any corrections necessary. Is that correct, sir?
Yes, Your Honor.
Alrighty, thank you. You can research all of that information and make sure that you're able to provide the accurate information, correct?
Yes, Your Honor.
So may I proceed?
Yes, sir.
Mr. De Leon, I will go ahead and sign the document and I will make it part of the record. State, have you fulfilled your discovery and Brady requirement in this case?
Yes, Your Honor.
Counsel, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's file?
Yes, Your Honor.
State, is this matter subject to law enforcement disclosure? And if it is, has that been complied with?
Yes, Your Honor, it is complied.
The court will sign the discovery acknowledgement, making it part of the record. State, do you have any motions for the court's consideration?
No, Your Honor, they should not be necessary here.
I'm sorry, did you have any motions?
No, Your Honor, no motion.
Defense, do you have any motions for the court's consideration?
No, Your Honor, I don't, Your Honor.
Mr. De Leon Jr., I draw your attention to the document on display. It's entitled Defendant's Waiver of Constitutional Rights and the Court's Admonitions. This is a 2-page document. This is the first page, and then this is the second page. Mr. De Leon, is this your signature here where I am circling the cursor?
Yes, Your Honor.
Did you review this document with your attorney?
Yes, I did.
After you went over it with your attorney, did you freely and voluntarily sign this two-page document?
Yes, Your Honor.
With your signature and your testimony, you're telling me that you understand everything in this two-page document as it was reviewed and explained to you by your attorney.
Yes, Your Honor.
And are you satisfied with the representation of your attorney?
Yes, I am.
Very good. He has done very well to be able to bring this to a resolution for you today, sir. And so did he explain to you the punishment range in this case?
Yes, Your Honor.
And then explain to you as far as your constitutional rights?
Yes.
Did you understand your constitutional rights
Yes.
as well as the range of punishment?
Yes.
With your understanding of your constitutional rights, sir, do you freely and voluntarily give up your constitutional rights?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
I will approve your jury waiver. I am going to sign it, and Mr. DeLeon, you will no longer be able to have a jury trial in this case. Counsel, do you believe that your client is competent to enter into a plea today?
Yes, Your Honor.
With the information, were you able to apprise this defendant of the nature of the offense and the charges against him?
Yes, Your Honor.
Do you and this defendant waive the formal reading of this information?
Yes, Your Honor.
State, what is the punishment recommendation in this case?
Your Honor, the state recommends 12 months of deferred adjudication, $400 fine plus court costs, 24 hours of community service, the APSE course, and the defendant must forfeit the weapon in this matter.
Weapon forfeiture?
Yes, Your Honor.
Is the state's intention to go ahead and destroy this weapon?
Yes, Your Honor.
All right, and that will be forthcoming?
Yes, Your Honor. I think the state might have already filed it, actually.
Counsel, is that your understanding of the state's punishment recommendation in this case?
Yes, Your Honor, it is.
Mr. De Leon, is that your understanding of what your attorney has worked out with the state on your behalf in order to resolve this matter for you today?
Yes, Your Honor.
Or at least dispose of it. And so with that understanding, sir, how do you wish to plead? Guilty, not guilty, or no contest?
Guilty.
Actually, it was no contest, Your Honor.
No contest. Sorry.
What is the plea?
No contest.
Sir, do you understand that even though you plead no contest, I can still find you guilty?
Yes, Your Honor.
And you still wish to proceed?
Yes, Your Honor.
Now, Are you pleading, with your plea of no contest, are you telling this court that you do not wish to fight the charges in this case?
Yes, Your Honor, I don't want to fight the charges.
And with your plea of no contest, you're telling this court that you believe that that is in your best interest?
Yes.
I will accept your plea of no contest, finding that it is intelligently and freely made and that you're competent to do so. Counsel, what, if anything, on behalf of your client and why I should consider this plea?
Your Honor, we're asking the court to honor the plea bargain agreement. Our client, Mr. Bobby DeLeon, he understands the seriousness of the possible consequences of this type of offense. Since that date, he's focused on personal rehabilitation as far as being mentally strong, mentally healthy. He's got a good family support system, and he's respectfully asking the court to honor the plea bargain, Your Honor.
Thank you, counsel. That is very helpful. Who was the owner of the weapon?
I'm sorry, Your Honor, it got cut out. Apologies.
Okay, who was the owner of the weapon that was discharged?
I need to consult with Mr. DeLeon, Your Honor. I don't have the answer right now. Bobby.
Do you wish to be placed in a breakout room to consult with him? Or
Yes,
did you wanna-
yes, Your Honor.
You wish to talk to your attorney privately?
Yes, sir. I mean, yes, ma'am. Sorry. Yes, Your Honor.
We'll go ahead and suspend record. You guys should have access to the same breakout room that you were in.
Thank you, Your Honor.
Attorney Blake? CLOs,
Yes, Judge. I'm sorry, Judge. I never had a chance to speak to Mr. Zimmerman. He never joined the breakout room.
oops. Let's find out where he's at. Okay. Send her there, please. Please, with them. Okay. He's waiting for you in another room. Sorry about that, Celia.
Thank you, Judge.
Attorney Kagan? I hope this is a short matter, sir.
Yes, Judge, I'm ready on that plea on Mr. Hosick.
You are what?
I'm ready on the plea on Mr. Hosick.
Okay, thank you. Let me go ahead and check if I have that paperwork, sir. Attorney Hernandez, Flavio Hernandez.
Yes, Your Honor. In my condition, Your Honor, I'm reminded of what the Roman gladiators said at the arenas.
What's that?
We who are about to die salute you.
Counsel, I hope that we are really not at that stage, but counsel, if you You have been able to marshal all other requirements for representation in this case?
I do have one lawyer who's assisting, who's able to assist. I think it's more or less a voluntary. He's not appointed as co-counsel, but he's pitching in. I've only had one conversation with him prior to becoming sick. I have not been able.
Counsel, you have been able to basically, is that a yes? You have been able to, because you had some concerns at the last
Yes,
conversation.
it is a yes for the
Those-
future, and it has not happened yet. I mean, there's been one conversation so far, but he's available for me for the future. Yes.
Counsel, what I'm trying to be able to ascertain is that your concerns, because this is a second motion for continuance, and you are indicating medical issues, but your prior concerns concerning being able to be ready and have the resources ready to be able to tackle on this case, those have been addressed, correct?
Correct.
Okay. All righty, counsel.
Yes, Your Honor, I have made progress. I do know of an investigator. She was not available for the,
Counsel?
yes. Never mind.
I'm not, with the details is not something I wish to,
Sorry.
we're not on record at this time. I just, you know what the issues were, that your concerns, and that presented to the court, and the court has been able to assist you to address those concerns.
Yes.
Okay, so counsel will see you, since you are moving forward with that. And again, get well soon. We'll see you on the 8th of December. Please feel well, okay? We'll
Oh, Your
continue
Honor,
to.
that is not sufficient time. I have lost 10 days, Your
Okay.
Honor. I have lost 10
Alrighty.
days.
I understand, counsel, but as you are recovering, let us proceed diligently, because the resources that you have asked for, they're independent of your participation. So see you on the 8th of December. Just make sure that your resources are working, okay, sir?
Thank you, Judge.
And please get into a breakout room with the court coordinator to get that case reset for the 8th of December.
Yes, Your Honor.
Thank you. Attorney Blake, I'm sure your matter is very short, but I'm very close to being able to complete this plea. And before I go into the other plea, I promise I will get back to you. I beg your patience just a little while. Thank you. Let us get back on record on cause number 674-527, State of Texas versus Bobby De Leon Jr. At the time that we suspended the record, the defendant wished to speak with his attorney. Counsel, are we ready to proceed?
Yes, Your Honor, just getting the answer to the question, Your Honor, for who's the owner of the weapon. Yes, ready to proceed.
And defense, excuse me, state, you're ready to proceed?
Yes, Your Honor.
Counsel, exactly correct. I had asked who was the owner of the weapon.
Yes, Your Honor. Mr. De Leon, Mr. Bobby De Leon, the defendant, is a registered owner of the weapon. Your Honor.
Junior?
Junior, yes, sir.
Okay. And okay, just wanted to go ahead and make sure with regard to the destruction of the weapon. And Will I be able to get an affidavit that states that there are no other weapons accessible to Mr. De Leon for the term of operation?
Yes, Your Honor. When would you like it, Your Honor?
Within 10 days.
Okay.
That's 10 calendar days. Counsel, is
Yes,
there,
Your
just one more question with Mr. De Leon. Is there any physical or otherwise reason why you are not employed?
Your Honor, if I may, he's been focusing on his mental health, Your Honor. And although I don't have proof of a letter from the doctors, he has been focusing on that issue. He's capable of working, but at this time, he was just following his instructions of his therapist, his doctor.
ADA Han Martinez?
Yes, Your Honor.
If you would be kind to go ahead and accept the invitation that I just sent you. And counsel, we're going to suspend the record at this time. Counsel, if you would go ahead and you and your client get back into that breakout room that you have been using, I'll join you. And court reporter, would you please go ahead and join us? Mr. De Leon, can you get back into the breakout room that you were in before?
Okay.
Look at the three dots on the bottom right hand of the screen, and you should be able to see breakout rooms. And
join breakout. Okay.
Right.
Thank you.
Recording in progress.
Counsel, is there any legal reason? Oops, sorry. Counsel, is there any legal reason why? Oh, I'm sorry, we're back on record on cause number 674-527. Counsel, is there any legal reason why this matter cannot be disposed of today?
No, Your Honor.
Mr. DeLeon, although there is sufficient evidence to find you guilty, I'm going to withhold my finding of guilt, and I'm going to place you on 12 months of deferred adjudication community supervision for discharge of a firearm in a municipality or with the population greater than 100,000. You're going to be supervised and monitored by the Community Supervision and Corrections Department. That's the probation office. On behalf of this court, with the following conditions: $400 fine plus court costs, 24 hours of community service restitution. I believe it's anger prevention and stress education, APSE course, gun safety course, and also no firearm, an affidavit that states that you will not have any firearms through the term of probation. The state counsel, you have no objections to the destruction or forfeiture of the weapon?
No, Your Honor.
And the once that's tendered by the state, weapon will be forfeited and destroyed. Mentioned as far as the affidavit, and then proof of enrollment to a trade school once you're enrolled. Make sure to provide that to your probation officer. And then I'm going to set your supervision fee at $25. State, did I cover everything for you?
Yes, Your Honor.
Counsel, anything further?
No, Your Honor. Thank you. Thank you very much.
Thank you. Mr. De Leon, with regard to the trial court certification of defendant's right of appeal, this has been a plea bargain case, and I am certifying that you have no right to appeal. You will get a copy of this to get a copy of it from your attorney. State, would you be requiring a fingerprint on this case?
Well, Your Honor, I'm not sure. I think normally we do, but not sure if that was part of the requirement here. I'll have to double check here.
Okay. While you're checking, I will go ahead and finish up with Mr. De Leon. Thank you so much for being and availing yourself to be to resolve this matter for you. I wish you great luck with your trade school and everything that you have going on with your life. And sir, 12 months is a long time to be on probation. Make sure that you communicate with your community supervision officer, your probation officer, if there's anything that might impede or kind of get in the way with you being able to satisfy and complete your probation satisfactorily, okay?
Okay, Your Honor.
Alrighty, your attorney has worked hard in getting this matter resolved for you. That's the way to go ahead and thank your attorney, is for you to be successful, and it's important for you to be successful and make contribution to this society as you're destined to do.
Yes, ma'am. Thank you.
Alrighty. State, do you have any objections to Mr. De Leon being referred to the Bear County Gives Back Program for satisfaction of his community service restitution?
Sure, Your Honor.
Counsel, are you familiar with that program?
Yes, Your Honor.
Okay, the CLO is here and can explain that to him. I just need her to be able to complete this particular case, and then we can put him in a breakout room with her, okay?
Okay.
Alrighty, so Mr. De Leon, you just hang on a second and the CLO will explain to you the Bear County Gives Back program. It is an alternative means for you to be able to complete your community service restitution, okay?
Okay, Your Honor. Thank you.
Thank you so much.
Your Honor, looks like in the documentation, the state did not request submission of fingerprint sample as part of the plea agreement.
Okay.
Thank you.
Alrighty, we're off record. Thank you.
Thank you, Your Honor.
Okay, good. Alrighty. Attorney Zimmerman. Oh, let me stop sharing. Oh, did I? Oh. Okay. Attorney Zimmerman,
Yes, Judge.
are we ready to conclude, or is there going to be?
Judge, I would request the restitutional matters. I'm going to be researching that. I would request a couple of weeks to get that researched and reset the case for a couple of weeks, Judge.
You can come back next week, real early. I mean, Mr. Chapko is in custody and we want to be able to determine, be able to settle this matter so we know what he's going to do, either treatment or.
Yes, Judge, I'm looking at my schedule. I've got a trial scheduled on Monday that I think we're at the top of the list, so I think that's got a really good chance of going. I've also got a trial scheduled on Tuesday. And so could we come back on Friday the 9th? Would that be possible?
If that's the earliest that you can go ahead and be able to.
Well, I see a little gap in my schedule, and that is on Friday, the 9th. Monday, Tuesday, Wednesday are completely booked, and a good chance of me being in trial. Maybe the 8th, but the 9th looks like that's the best bet that I'll actually be free to attend court, Judge.
Okay, just want to make sure that you consider all implications, and Mr. Chapko is electing to do time as far as being in custody either way. So we'll see you on Monday, sir. We'll put you in a breakout room for you to get a case setting form and be able to, so that would be provided to Mr. Chapko as well.
Okay.
So
you would like to see me on Monday, the 5th then, Judge? Is that what you're saying?
No, you said on the 9th, correct?
Correct.
Okay.
So that would be on Friday, the 9th. You would like to to reset this.
Get a
tape.
case- Sir, at this time, you're saying that the earliest that you can be able to address this, conclude this matter is on the 9th of December, Friday,
Yes,
9th of.
I'm looking at that date. Yes, Judge.
Alrighty, placing you in a breakout room so that you may be able to get a case reset form. I'm going to place you and your client in that breakout room, okay? With the court
Okay.
coordinator.
And then I will also confer with your court coordinator and get that form sent to me so that way we can get that filled out, Judge.
Okay, sounds great. Thank you very
Okay.
much.
All right,
Cielo-
thank you, Judge.
Okay, let's go ahead and move Attorney Zimmerman. And then Cielo Tejas, can we move you into the breakout room with Mr. De Leon?
Yes,
Actually,
Judge.
yes, Judge, if I could confer with my client as well, too.
Yes. De Leon, I'm going to move him. Attorney Blake?
Yes, Judge.
Okay. Oh, Attorney Kagan, I have checked for the paperwork and I don't see it. Would you be able to get into a breakout room with the state and find out the status of your paperwork? I'm going to just check it again real quick here.
Judge, I see it's sitting with the defendant.
Oh, thank you. Counsel, the defendant, where is the defendant? Mr. Hoshek. He's sitting here,
He's present in the courtroom.
right? Could we put Mr. Hoshek in the
I just sent him a reminder if that helps, hopefully.
He's gonna need a device.
Just open up the new window. Yes.
He has to go into his room.
Right, please go to this. All right, counsel, we're going to go ahead and situate your client.
Okay.
And in the breakout room, then I'm go, please is your counsel, is your client pretty savvy? Should I give him ability to share with you, or just in case he needs to share his screen with you?
I've explained the paperwork to him already, so I don't think we need that.
Okay, not a problem. Let me go ahead and place you in the breakout room with him. Alrighty, let's go ahead and put them in the breakout room in case he has any questions. Alrighty, Attorney Blake,
Yes, Judge.
your case.
Yes, Judge. Number 15, he's applied for the VTC. We're just asking for a reset so he can complete his application.
Okay, Garcia.
Judge, if I may interrupt, it's Cielo Diaz. May I be excused, Your Honor?
Oh, yes, if you're done with Mr. De Leon, thank you so much for your help. I don't think that we have any matters pertaining to probation. Attorney Stetson, your case doesn't require probation, right?
Mine is a conditional dismissal. It's in your inbox. The prosecutor, Ms. Martinez, emailed it to you.
As Attorney Hernandez, does your case require probation involvement?
Not mine, Judge. Thank you.
Yes, Officer Taya Santos, thank you so much.
Thank you, Judge.
Judge, I can't log him on. I let him log on to that because it doesn't have Google Chrome. He's on. He did that from Google Chrome.
Excuse me a second.
He's gonna, I think, send it to Morena. He's gonna sign it physically.
That may not work because state discovery acknowledgement.
If you go with the storage, may I go?
Yeah.
All I know is that we can't download it.
No, yeah, because that's all I can do, because you can.
Judge, are you reviewing my case?
Okay. State, can you pull up cause number 683169?
Whatever, Your Honor.
You ready?
Yes, Your Honor.
Okay, let us, oh, I don't have my court order. Counsel, we can do an electronic record of this if that's okay with you.
Yes.
Alrighty. State, that's okay with you for an electronic recording?
Yes, Your Honor.
Let us get on record on cause number 683169, State of Texas versus Jacob Natalio Garcia. We have a parties, please approach and I'm so sorry. We won't be able to do that on an electronic recording. I'm sorry. We won't be able to do it. So just hang on 2 seconds. My court reporter will be right back. Okay. Attorney Stetson?
Yes, Judge.
Okay. Okay, Attorney, Mr. Moreno, Andrew Moreno, please approach. Yes, sir. Council, I believe that we were here, what was it, yesterday, regarding the completion of conditional requirements, conditions on Mr. Moreno.
That's correct.
Okay, as state, has the defendant, as far as provided you record and has completed the conditions warranting a dismissal?
Your Honor, I'm not sure if I have that personally. I think there's been discussion with my co-counsel. I'm not sure if defense counsel can elaborate on that.
They have been provided to Ms. Martinez. I e-filed the remaining 7 hours that was outstanding. The other documents were previously provided, anger management class. It's been e-filed. Previously, 17 hours proof of community service were e-filed. And this morning, my client finished the remaining 7 hours for a total of 24 that have been e-filed. And the clerk, Julia, had placed a copy of today's filings in your basket. You should have a copy of it.
ADA Han?
Not sure if she's available. Oh,
Yes, Judge?
You had tendered this dismissal based on the fact that the defendant has completed all the requirements and you have the documentation.
I have, and I also received notification of the e-filing.
Sorry, I'm sorry, say that again.
Yes, I received the documentation and believe it to be true and correct. I also received notification of it being e-filed.
Mr. Moreno, thank you so much for the efforts that you have made in order to comply with the generous offer of the state. They have tendered a motion to dismiss. Are you able to see that on my screen, sir? Alrighty, I am going to go ahead and sign it. And you should get a copy of that from your, that have signed it. You should get a copy of it from your attorney, okay? If a copy of it doesn't come straight to you, thank you so much. And you are free to go. Appreciate it. Appreciate your efforts. All righty, thank you. Counsel, anything further?
No, that was the only client today. Thank you, Judge. I appreciate it.
Yes, thank you. Counsel, you have yourself a great weekend. Thank you,
too.
State.
Thank you, Ms. Martinez.
Yes, Your Honor. Okay.
Attorney Oscar Hernandez, are we taking a plea on your case, or you filed a motion for continuance?
We're returning from yesterday's trial announcement. I did file a motion for continuance, but my client's phone had died yesterday afternoon.
Is he here now?
I was told he was there this morning in person.
You want me to check, Your Honor?
He was here after those two, and then he walked out. Can you tell that he offered me? He's dressed in all that enforcement here.
Mr. Bond, right, Jamal Bond?
We're getting him, counsel. He has stepped out.
Thank you.
It looks like he's actually outside these doors. If you like, ask him to come in.
Yes. Okay, ready? Okay. Counsel Hernandez, you'll be right after Attorney Blake. Attorney Blake, let us get on record on cause number 683-169, State of Texas versus Jacob Nathaniel Garcia. Parties, please approach and identify who's before the court, starting with the state.
Victor Hernandez for the state.
Angela Blake, attorney for Mr. Garcia.
Jacob Nathaniel Garcia, please unmute and respond.
Yes, Judge. Jacob Garcia.
Thank you, sir. Let the record reflect that the defendant is in this court session with his attorney. Counsel, we are here for a hearing, and you understand that there is a 1622 report associated with your client, right?
Yes, Your Honor.
Okay, very good. We had a pretrial conference hearing on this matter on the 19th of May 2022. Set it for a pretrial conference hearing, and I believe you set it for a trial. the dates of that was the 3rd of November 2022 and 7 November 2022 was the trial date. So council, today is the 2nd of December, and I have indicated here that we are here for hearing on what matter.
We applied to the VTC, Judge. It still hasn't been accepted. We're still in the process of VTC application.
I do not see a jury waiver in here nor a referral to the Veterans Treatment Court.
He has been going through the, oh, sorry. He's
Sorry.
been going through that process.
Sorry, I see it here. It was signed by Judge Herr here on the 3rd of November. And so tell me what's going on. Where are we on this matter?
So there's medical records that the VTC is requiring. Mr. Garcia has requested those of the Army, and they're supposed to be in December 6th. And then I'm not sure the next stage after that. I think that may complete the application, but I don't know the next step in the process. I think it's, Mr. Garcia may know more, but a reset is required. I would just ask for a reset at this point.
Okay. Counsel, do you have a date in mind?
If you want to set it for 30-day reset, maybe early January, that should be
Okay.
plenty of time for them to make a decision.
I would would hope so. So if you would check your calendar.
How is, can we do the 12th of January?
Council, considering the holidays and everything like that, did you want to give yourself a little bit more time? Like say the 6th of February or something of that nature?
Sure. Let's go with February 9th.
February 9th. Okay. All right, Council, that sounds really good. Thank you much. I appreciate it. And the Mr. Garcia, I wish you the best of luck. I'm sure that that particular court will be very beneficial to you, okay?
Yes, Judge.
But first of all, what service did you serve?
I'm in the Army currently.
You're
Judge.
currently in the Army.
Yes, Judge.
Are you the same guy who's chairborne?
Yes. Yes, Judge.
Yeah, we went through. I thought I remembered you. Yeah. It's okay that you're late, all right? It's okay. It's okay. All righty. You take care of yourself. Have wonderful holidays, okay?
Good.
And you keep up the good work and your service to the country. We thank you for the sacrifice that you're making on behalf of your fellow citizens.
Thank you, Judge.
Thank you. All right. Council, anything else?
No, Your Honor.
There you go, representing a lake. I mean, Attorney Blake, we're gonna have to talk. You guys have a great weekend. Thank you for your patience.
I see. Thank you.
Okay, let's go ahead and get that reset form. Okay, Attorney Oscar Hernandez.
Good afternoon, Judge.
Good afternoon, sir. Let's see, Garcia, side. We're here, we're going to state, are you ready on cause number 679210?
Your Honor, were you asking me? Oh,
Yes. Are you ready on, are you ready to go on cause number 679210?
oh, yes, Your Honor. Yes.
Let's get on record on cause number 679210, State of Texas versus Jamal Lawan Bond. Parties, please approach and identify who's before the court, starting with the state.
Victor Hernandez for the state.
Oscar Hernandez for Mr. Bond.
And are you Jamal Lawan Bond?
Yes.
Okay, let the record reflect that the defendant is in the courtroom in person, and his attorney is on Zoom, and he is here present in the court with his attorney. And counsel, I have here I believe that you filed a motion. We were here yesterday, and we had some issues with as far as your client being present. I think yesterday we were here for trial announcement, counsel.
We were scheduled for trial announcement. Yes, Your Honor.
Okay, and so you mentioned that you wish to be for us to recall this matter because your client wasn't present. And so we are here. Are we ready to proceed with the trial announcement? State?
Yes, Your Honor.
State, are you ready to proceed to trial on this matter?
Yes, Your Honor.
State announces ready. Defense, are you ready to proceed to trial on this matter?
No, Your Honor.
Defense announces not ready. Defense, have you submitted a motion for continuance?
Yes, Your Honor.
State, do you have a copy of that motion for continuance, and have you reviewed it?
One moment, Your Honor. I'm not sure if I got that copy. Oh, yes, Your Honor. It looks like I did receive a notice of that, and I did review it. Yes.
You do have the motion for continuance?
Yes, Your Honor. Yes.
Counsel, your motion, please proceed.
Your Honor, I have filed a motion for continuance. I have spoken with Mr. Bond, and he's persisting in his desire and intention to retain private counsel. He has maintained this for beginning when I spoke with him back in August, and then he texted me as late as yesterday of his intention. He's just asking for additional time to accomplish this action. And I'm glad he's here. He can address the court of his intentions. Additionally, I have filed I observed in reviewing the file that I had not tendered to this court the blood warrant drug testing discovery, as I had mentioned to the court back in September. And to go forward for Mr. Bond's defense, it is absolutely necessary, as the results came back minimal with respect to alcohol, and it's going to be alleged on drugs. Of course, he'll need to be able to scurry the facts on that, of whether that was done properly. In Your Honor, and it's not on my motion, obviously, but I believe I received over the night that there's been uploaded additional evidence of videos with respect to Mr. Bond's matter.
When was that uploaded? And
This afternoon, I was looking at my emails. I have a Bexar County e-discovery new evidence today at 1:33 a.m.
State, could you address that as far as the discovery, e-discovery?
Oh, one moment, Your Honor. Let me see what came up here. I'm sorry, Your Honor, I don't see anything in my system indicating if there's a new document. I'm not sure if defense can elaborate on that. It might help me find it there.
Defense? Did you hear the state?
I did. I don't know what can allow me to share screen. I'm looking at the email I received last night. It concerns two videos for this JN of 2058354 for Mr. Bond's matter.
Let's go ahead and let you share, have the ability to share.
Are y'all able to see my screen?
I can see it, Your Honor. And I'm sorry, Your Honor, I don't see anything with similar serial numbers, so I'm not sure if that's referring to specifically.
The JN in this case is 2058354, correct?
Yes, Your Honor.
I'm sorry, State, what did you say with regard to this?
Your Honor, I see nothing in my system relating to those serial numbers on display with the defense counsel screen.
Excuse me, Counsel, could you just scroll up just a little bit?
Yes, ma'am.
State, do you see what he's showing?
Yes, Your Honor.
As a cause number, it appears that there's supplemental discoveries. State?
That's what it looks like to me.
Okay. And so, okay. So State, you're testing this?
I'm not sure what you mean, Your Honor.
You're at this time, State, going ahead and testing the blood?
Your Honor, as I understand, a drug lab report already came out. I thought defense might have gotten a copy of that.
We have a copy of the results, yes. Our intention, as mentioned back on the arraignment date or the announcement, was that I was going to be requesting the discovery as for the standing order and by their procedures, which I had not done.
It says it looks like it's going to take some time, so looks like it's going to require a reset in the trial date.
Okay. All righty. And so, Counsel, we have the discovery figured out as far as the supplemental discovery and as well as the blood the standard discovery and blood test record, of which my notes state that was going to be filed, and I may have miswrote this, but it looks like the 6th of December. That was going to be filed, and as you've indicated in your motion here for continuance, that has not been done. So having addressed the discovery issues, you also have stated here that Mr. Bond is requesting to be time to hire an attorney, another attorney.
That is absolutely the information I'm given by Mr. Bond. And if I don't mind if the court would address directly with Mr. Bond, he can address this court as well.
Okay. Mr. Bond, is that what you have expressed? Excuse me. Are you requesting time to be able to hire an attorney?
Yes, ma'am.
And so this case has an offense date of the 13th of February, 2022. We're here almost 10 months later, And if you have, as your attorney has indicated, you've been requesting this for a long time, what has happened? Why haven't you hired somebody?
Your Honor, I have a new girlfriend, moved from out of state. She got pregnant and I just had a baby Tuesday. That kind of been my sole purpose, my sole focus. As I spoke to Miss, what's his name? The attorney.
Attorney Hernandez?
Yes. The day I got whenever I made my first initial court appearance, I was assigned to him and to contact him the next day when I got out or whatever. I did so, and that is when I heard from Mr. Hernandez. I assumed that because my charge was DWI, once the blood test came back, that it would be dismissed. But I was just informed that that wasn't the case. That's when, so basically, he told me the blood test wouldn't come back for 5 months. So in August, that's when whenever he told me that, that's when I said, well, I'll hire counsel, you know. He said, oh, the blood, I got the results for the blood test. And you, the court want to know what you want to do. I said, well, I'm a hire an attorney, because I thought that the case was going to be dismissed, but obviously not. So that's why I didn't hire an attorney. He texted me and told me, well, the court, you don't have to come to court. The court.
When we're going through certain proceedings and how to be able to dispose of the case, the court does excuse defendants. So you can keep on working and you're focused to be able to spare, as far as the time is concerned, to be able, considering your time, okay? Trying to alleviate the burden of coming to court and all the time spent here. You understand that you are free to have anybody represent you. The Sixth Amendment right says you have absolute right, constitutional rights to an attorney of your choice. You understand that?
Yes.
Okay. I just want you to make sure that you understand that this case has been pending since February 2022. It's 10 months down the road. Alrighty. This court took the time to be able to appoint to you one of the most experienced and best attorneys in San Antonio. Very, very competent attorney and one that is a zealous advocate for his clients. I've seen him work. So your choice, sir. However, this has been 10 months down the road, and we appointed Mr. Hernandez in April to be able to assist you with this case. And so how much time do you need in order to hire? And it's not going to be very much time I'm going to give you, sir. Because it's been going on for 10 months, and you said in August. If you knew in August that you wanted to hire somebody, that person should be on board already.
I understand it. Well, like I said, Judge.
Usually you get about 30 days.
Well, I mean, I don't, can't give you a specific date, but like I said, I just had a newborn baby, so I'll try my best to hire a lawyer. But as far as Mr. Hernandez is concerned, I don't feel like he represented me. Everything is last minute. He told me I had to go, he texted me and told me, hey, you gotta go to court tomorrow. I'm like, well, I went to work. That was my second time even speaking to him.
Yeah, and sir, you understand that you've been here before, correct?
Yeah.
Because we provided you a form. And although the phone number of the court is not on that particular continuation, everything else concerning information, how to get in touch with the court to include phone numbers is at least one on the website, two on the paperwork document that you received. And also, sir, here that the court's information, it is up to you to keep track of your case, sir. You can call the court directly at any time and be able to know when your court date is, and you should be checking on that. Okay, you can call the court and say, hey, this is me, and know your case number. And that's helpful, but I'm sure you know your date of birth to take that information too, and they'll be able to tell you what the dates of your court. Okay, just so that you know that ahead of time and put that on your calendar. So how much time are you requiring, sir? It's not going to be more than 30 days, sir. And I'm being generous at that because you knew you wanted to do this in August. I should only give you about a week or 2 weeks. Case is 10 months old already.
I need 30 days.
Okay. Hey, do you have any comment regarding motion to continue? The defendant's motion to continue.
Yes, Your Honor, the state agrees with continuing 30 days. I'm just not sure, would that be a pretrial conference? Since it's a new attorney?
Let your new attorney know that you are on the trial track. I would not wait till 30 days to hire an attorney. I would get one within 2 weeks and let him know that you are on a trial track. Okay, because just because you have an attorney, we don't begin all over again. It continues. Do you understand that?
Yes.
I'm going to reset this for the 9th of January, 2023. And sir, you need to come and appear. And have your, by 8:30 a.m. Okay, council, your motion for continuance is granted. And this matter is reset for the 9th of January 2023. Sir, you need to be here by 8:30 a.m. We'll get you a case reset form here. And again, you are admonished to make sure that you hire an attorney soon. They have to put in a notice of appearance. I will do that very soon, okay? And be ready to, so he'll be ready to be here by the 9th. All righty? Okay, you go ahead. Counsel, do you have anything further? Hold on, Mr. Bond. Anything further, counsel?
Oh, Your Honor, that's all we have for this afternoon. Thank you very much.
Thank you very much. Then go ahead and have a seat. Reset form will be, sir, your excuse. I appreciate your service to the bench, to the court.
Thank you, Judge.
Thank
Good
you.
to see you again. Bye-bye.
She's in there. And this gentleman here, Thomas Haley, never showed up. So. Mario said yes for 90 days.
Oh,
Never showed up.
Attorney Hernandez?
Oh, me, right?
Yeah.
Sorry,
Oh,
Mr.
no, yeah.
I'm sure if you meant to get defense attorney, I guess he left. Sorry, Judge.
Yes.
Judge, is there anything else you need the state for? May I log out?
One more case. They're working on it.
Okay, I'm going to take a real quick break.
Of course. Edia Hernandez,
Oh, yes, Your Honor.
could I please trouble you to have the court coordinator come here, please?
What coordinator? Oh, yes, sir. I'll look for her.
Or Jesse, or the bailiff.
Marina, you sent you the paperwork on Tusk.
Nope, I think that's it. Hold on, right? I'm sorry.
Judge, I just approved the paperwork for the plea. It should be in your inbox.
Ms. Luna, I'll need for you to step out here to the courtroom, please. Thanks.
For Mr. Bond?
I need for you to step out here to the courtroom, please. Thank you. Mr. Bond needs to reset.
That's right.
File, and from 9
Do you have his file?
January. Mr. Bond. I still have to. Want to make a note of it, but that's that for the reset. I'm sorry, what is, Deputy, what is this gentleman's name?
Number 9.
Okay, thank you. Hmm.
Yeah.
Sir, please approach.
This is Spanish speaker, Judge. ¿Tienes un poco de inglés?
Yes.
So if you understand English, she needs.
Some words, I don't know, sometimes.
Señor, espera hasta que ella le hable. No comience a hablar.
Abogado, when is the last time you spoke to your attorney?
About 4 months or 3, the less court I have here a couple of months ago. He talked to me on the phone and he said, you got some more stuff in your case, Antonio is coming, some more stuff. And then I called a couple of times to explain to me, and I called a couple of times and he never talked to me. And I feel real bad, so I don't call no more. Yesterday, I called this week, I called a couple of times and really, all these years, looking for help everywhere with police, with lawyers, with friends, ladies, men, and not find this man today. And he said, he want to help me. He said, he want to help me. He said to me, give me the phone for your lawyer. Let me tell him he needs some help to call me. So I give you the number to this man for my lawyer to communicate you. But a couple of times I called the police to help me with this lady, and the police never helped me. And I got proof. The report.
Sir, I don't need to hear about the facts.
I'm
of it.
sorry.
It's okay. I just wanted to.
I'm sorry.
As far as your
I'm
attorney.
sorry. And I know I make a lot. I know I'm making mistake. I'm not perfect, but
So nobody is, it's okay. It's all right. Look at the box. Yes, I need to still document that. You know where the Can you tell where the felony case is in? What court?
I don't know what you're talking about.
Oh, it's the 290th. He went to the 290th this morning. This is a gentleman who went to 290th.
Yeah, I think I looked him up this morning, but I don't think he's been indicted yet. That's why he doesn't have a court date.
Right. But it was the 290th, correct?
Right. If I remember correctly, I think he hasn't been indicted. That's why he doesn't have a date. This says what date he was released.
So Mr. Healy is on your felony case as well. He's on your felony case. You went upstairs?
He's there?
Okay. No, he
Oh,
was
oh.
he there this morning?
Yeah, I got it. He explained to me over there. He said to me,
Okay,
Lord
you
Bar
saw-
Antonio,
you-
you obviously said the day you need to come to court. This morning, he said to me this.
So you saw him?
No, only the lady in there said to me, the lady secretary, like,
Yes.
he said to me, Antonio, don't worry about it. It's not ready. Your court is not ready. Later, Mr. Thomas, your lawyer, he call you to say your date. Or he the court send a paper to your house with the date. with court.
Abogado, was he there?
No. Well, I don't see any. In the what he said to me, the lady, what he said to me.
Okay.
I want, I need really, I need a help to a lawyer to listen to me about everything what happened. I have right here a little bit information about what kind of person, what I do with this lady, the way I give you my,
Mr. Barbosa.
I'm sorry.
I just need to make sure that you get representation for this case, okay, as well as your other case. I want you to have a lawyer. The lawyer that is on this case, your abogado here, in this case right
Yes.
here, okay, is the same as the one upstairs.
Yes.
Okay.
Yes, that's the same.
Right.
Yeah. I know.
So I don't want to split it at this time. Okay.
Well, I called my office. I need to call to my office official. I have in my feet about 7 months with the motor in my feet.
Okay. Alrighty. Thank you. This is what I'm going to do. When would be a good time for you to come back? When can you come back?
Monday.
Monday? This Monday? This Monday, okay? Okay. Why don't, because Monday is crazy, can we make it Tuesday? Tuesday, okay? All right. Then I want you to come back Tuesday.
In the morning.
In the morning would be okay.
In the
Okay.
morning.
In the morning would be okay. Give him a recall, a reset form, case setting form for Tuesday. Alrighty, and make sure that Attorney Healy understands that he needs to be here Tuesday, no bail. He must be here on Tuesday. Okay, so we can see what's happening. Okay. Okay.
See, you see,
Wait, she'll give you the paper.
oh,
Okay.
I can say something.
Can I have him sit down there?
I can say something. I can say something. I go to Mexico a couple of times to help this lady in the
Sir,
house.
Sir,
Uh,
I can't hear
Oh,
that.
I'm sorry. Okay,
can't hear
Unreal,
I understand.
Unreal.
I know you're upset.
Okay, thank you.
Okay, that's why I want you to make sure to get you some help, okay?
Thank you.
Okay,
Thank you.
no problem. You just wait for paperwork,
Thank you.
okay?
Muchas gracias.
Si me permite, ahorita le doy su documento. Espérame.
Nomás espérese acá. No parece que-
¿Me puede dar su dirección a donde está viviendo ahorita? Su número telefónico y su... ¿Y usted puede recibir correspondencia ahí?
Let us get on record. Court is going to get on record on cause number 664-639, State of Texas versus Richard Albert Hoshek.
Yes, ma'am.
Thank you, Hoshek.
Thank you.
The parties, please approach and identify who is before the court, starting with this state.
Victor Hernandez for the state.
Jerry Kagan on behalf of Mr. Hosek.
Are you Richard Albert Hoshek,
Yes, Your Honor.
the same that has been accused of driving while intoxicated, second offense alleged to have occurred on the 3rd day of July, 2021,
Yes,
and is considered classified a Class A misdemeanor?
yes.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth under pains and penalties of perjury, so help you God?
So help me God. Yes.
Thank you, sir. You may go ahead and place your hand down. Court, the defendant and the state are in the courtroom physically. However, the defense attorney is on the on Zoom. So the court is going to share the court screen as we are operating hybrid. Mr. Hoshek, can you see the court screen?
I think I can make it out, Your Honor. Yes,
Can see it, okay?
yes, ma'am.
All righty. And counsel, can you see the court screen?
Yes,
State, can you see the court screen?
Yes, Your Honor.
State on display is a document entitled State's Consent to Video Conferencing. Did you sign this document that's consenting to these proceedings by video conferencing?
No, Your Honor. Assistant District Attorney Ling Han signed it for the state of Thompson, Your Honor.
State's video conferencing consent is made part of the record. Mr. Hoshek, is this your signature on where I am circling the cursor on a document entitled Defendant's Consent to Video Conferencing?
Yes, Your Honor.
Did you sign this document thus consenting to plea by video conferencing?
Yes, Your Honor.
Counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
yes,
The defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Mr. Hoshek?
Over a year.
And counsel, are we applying for probation? And if so, what type?
Deferred.
Mr. Hoshek, on display is a document that's entitled Application for Deferred Adjudication Community Supervision. This is a 2-page document. This is the first one. And then this is the second page. Here about the middle of the page where I'm circling the cursor, it states that you personally appeared before me. You are here in person.
Yes.
You are the defendant in this case, and I have sworn you in.
Yes.
Under oath, you're telling me that your application for deferred adjudication community supervision, along with your personnel data sheet, which is going to be attached as an exhibit to your application, is true and correct.
Yes.
Keeping in mind that both documents need to be completely filled in order to be true and correct. Do you wish to speak to your attorney to understand the consequences of your response to this statement, that the defendant understands and acknowledges that any untrue statement in his application or your exhibit, the personal data sheet, may be grounds for denial or revocation of community supervision in this case?
I don't need to discuss it.
And so that you understand and then you acknowledge, sir?
Yes.
I will sign the application, and your personal data sheet are made part of the record. State, have you fulfilled your discovery requirement and Brady requirement in this case?
Yes, Your Honor.
Counsel, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's files?
The state certainly has.
And state, is this matter subject to law enforcement disclosure? And if it is, has that been complied with?
Yes, Your Honor, the state has complied.
I will sign the discovery acknowledgement. I am making it part of the record. State, do you have any motions for the court's consideration?
Yes, Your Honor, the state moves to waive and abandon the enhancement for the second offense, as well as the enhancement for alcohol level above 0.15. And the state will proceed on a first offense charge for the Class B misdemeanor.
So state, it was charged as both, and it has over 0.15 and as well as a second.
Your Honor, as I understand from the information, it was just a second offense charge, and it did not say anything about the 0.15.
So you are waiving and abandoning the second and as an enhancement, being charged as a second enhancement and proceeding with GWI first? Class
Yes,
B?
Your Honor. Yes, that's correct. And as far as any enhancement of 0.15, the state will waive anything relating to that, and we'll just proceed on the Class B misdemeanor.
What say ye, defense?
No objections.
Without objection, that motion is granted. State, any other motions for the court's consideration?
No, Your Honor.
Defense, any motions for the court's consideration?
None.
Mr. Hoshek, on display is a document entitled Defendant's Waiver of Constitutional Rights and Course Admonitions. This is a two-page document. This is the first page. And now this is the second page. Is this your signature where I'm circling the cursor?
Where's that at?
Right there. See there.
Yes.
Middle of the page.
Ready?
Got it.
And did you go over this two-page document with your attorney?
Yes.
And after reviewing it with your attorney, did you freely and voluntarily sign this document?
Yes.
So with your signature and your testimony, you're telling me that you understand everything in that two-page document as it was reviewed and explained to you by your attorney.
Yes.
Finish talking and then you have plenty of time to talk, okay? She can't hear two voices at the same time. All right. All right. So, counsel, Mr. Hoshek, are you satisfied with the representation of your attorney?
Yes, Your Honor.
Good. And so he has been able to work. He's a very good attorney and he has been able to work out a very good deal for you, that removing the second enhancement and reducing this to a class B misdemeanor from a class A misdemeanor. So did it explain to you the range of punishment in this case?
Yes.
They explained to you the constitutional rights.
Yes.
You understood both of those, the range of punishment and the constitutional rights.
Yes.
With that, sir, with your understanding of your constitutional rights, do you freely and voluntarily give up your constitutional rights?
Yes.
Are you a U.S. citizen?
Yes.
I will approve your jury waiver. I am going to sign it. And sir, you will no longer be able to have a jury trial in this case. Counsel, do you believe that your client is competent to enter into a plea today?
He is, Your Honor.
With with the information, were you able to appraise this defendant of the nature of the offense and the charges against him?
Yes.
And do you and this defendant waive the formal reading of the information?
He'll waive it.
State, what is the punishment recommendation?
Your Honor, the state recommends 18 months of deferred adjudication, $500 fine with court costs, DWI intervention, U-Impact, 40 hours of community service restitution, $60 reimbursement to the Texas Department of Public Safety, TAIP evaluation, ignition interlock for half the term, that's 9 months, and restitution, if any, to the property owner at 602 FM 1516 North, San Antonio, Texas 78263.
You said 602 FM what?
That's a 1516.
1516.
Sure. And it has a north, so I assume it's 1516 North, and then it's San Antonio, Texas 78263.
Counsel, is that your understanding of the state's punishment recommendation?
It is.
And Mr. Hoshek, is that your understanding of what your attorney has worked out with the state on your behalf in order to be able to dispose of this matter for you today?
Yes.
With that understanding, how do you wish to plead? Guilty, not guilty, or no contest?
Guilty.
Counsel, do we the documentation since your client has pled guilty. And the documentation indicates here that it was nulo contendere. Do I have your permission to pen and ink change this defendant's waiver of constitutional rights and course admonitions?
I believe Richard meant to plead no contest since he's getting deferred.
Yes, I'm sorry.
You're sorry, what, sir?
No contest, Your Honor.
That's what you wish to plead, no contest?
Yes, Your Honor.
Now, do you understand that even though you're pleading no contest, I can still find you guilty
Yes,
and you still wish to proceed?
yes,
You've discussed this entire matter with your attorney?
yes,
And so with your plea of no contest, what you're telling this court is you do not wish to fight any of the charges in this case?
yes,
And with your plea of no contest, after discussing with your attorney, you feel that that's in your best interest?
yes,
I will accept your plea of no contest, finding that it is freely and voluntarily made and that you are competent to enter into such a plea.
yes. Excuse me.
Do you need a water, sir?
That would be nice. Thank you. Oh, you opened it for me too. Reverse chivalry. Thank you.
Counsel, what do you have on behalf of your client and why I should consider this plea?
Judge, we really don't have a long argument other than we would ask the court to consider following the plea bargain. This offense happened about 18 months ago and a lot of water under the bridge since then. So we would just ask the court to follow the plea bargain.
Mr. Hoshek, who do you live with?
My mom, but she's disabled. I'm helping her out. She has dialysis 3 times a week.
Does she have a vehicle?
There is a vehicle, but she cannot drive it, and it is not working.
What's your mother's name?
Joanne, Joann.
Say, what was the BAC in this case?
Your Honor, was 0.31.
Say, what was the previous prior cases?
Your Honor, from what I see, the prior case was looks like a conviction in January of 1992. Your Honor.
Mr. Hoshek, do you have the ignition interlock on your vehicle at this time?
Yes, Your Honor. Had it over a year.
And state there was an accident in this case?
Yes, Your Honor, it looks like, from my information, there was an accident.
I'm sorry, say again.
Yes, Your Honor.
What happened?
Oh, one moment, Your Honor. I have to bring up the police report here.
State, while you're looking that up, Ms. Luna, please go ahead and send the defense counsel a attorney authorization form for the DWI court referral.
Yes, Judge.
Counsel, if you'll be able to go ahead and sign that immediately and send it back to us, so we'll be able to go ahead and process it. Appreciate it.
I could be wrong, Judge, but I think we already did that and he got rejected. I might be thinking of a different case.
Okay, that will.
Oh, you know what? That was a County Court 12 case, different case.
You know, from what I see here, it looks like, according to the report, the defendant crashed into a fence at a residence.
And with regard to the restitution, this is to be determined by the Community Service and Corrections Department, Community Supervision and Corrections Department.
Your Honor, the state's position is that it does not oppose the defense reserving the right to a restitution hearing.
Understand, but it's to be determined, the restitution is to be determined by the Community Supervision and Corrections Department.
Oh, yes, Your Honor, yes.
At what time did that occur? Did it indicate the time of occurrence?
Oh, one moment, Your Honor. It looks like it was around 2 a.m. Oh, no, well, 1 or 1:30 from what I see.
The crush.
Let me double check, Your Honor. I'm still looking through this here.
Yeah, I believe it happened around 8 or so PM. Not in the morning, because I was already in jail.
Was my mistake, Your Honor. Yes, Your Honor. It looks like I think it was closer to 8 p.m. earlier. So as I understand, the report was later that night, but it looks like it was 8:24 in the evening. Yes, Your Honor.
So describe to the court the year, make, model, and color of the vehicle that the ignition interlock is installed in.
It's a 2007 GMC Sierra 1500. In the, oh, sorry, Your Honor. The color is like a bluish, lighter bluish color.
Thank you. Counsel, is there any legal reason why this matter cannot be disposed of today?
None, Your Honor.
Mr. Hoshek, even though there is sufficient evidence to find you guilty in this case, I am going to withhold my finding of guilt, and I'm going to place you on 18 months of deferred adjudication community supervision for DWI first. A Class B misdemeanor. You will be supervised on behalf of this court by the Community Supervision and Corrections Department, otherwise known as probation, with these following conditions: $500 fine plus court cost. DWI intervention program, uimpact.com, and a TAP evaluation. 40 hours of community service restitution. I'm going to refer you to Bexar County Gives Back program for completion of 40 hours of the Bexar County Gives Back through that program of your community service restitution. Counsel, are you familiar with the Bexar County Gives Back program?
Yes, Judge.
Okay. And $60 restitution to the Texas Department of Public Safety, ignition interlock for the half-term half-term of the I'm going to make it for 12 months, sir. 12 months of the probation term. You have indicated that you have already have it installed. And restitution, if any, to residents located at 602 FM 1516 North, San Antonio, Texas 78263. That restitution is to be determined by the Community Supervision and Corrections Department. I'm going to need an affidavit from you within 10 calendar days. One that says that you will not drive any vehicle that's not equipped with an ignition interlock. The second will be from Joanne Hoshek, that you have described to be your mother that you live with and who owns a vehicle, and that she will not allow you to drive that vehicle under any circumstances, albeit you say that it's inoperable. She can also include that in her affidavit with a third-party verification. And otherwise, I will need to order an ignition lock as I stated to be placed on that vehicle. That vehicle will be identified by year, make, model, color, last 6 digits of the vehicle identification number, and the license plate number. I'm going to order that you participate in the 12-step community-based sober support meetings 4 times a week. 2 of them must be in person. I'm going to refer you to the DWI DWI court, the specialty court. And I'm going to have your community supervision officer, probation officer, conduct a field visit. I'm going to set your supervision fee at $60. State, did I cover everything for you?
Yes, Your Honor.
Counsel, anything further on this matter?
Nothing further.
Mr. Hoshek, this, with regards to the trial court certification of defendant's right of appeal, this has been a plea bargain case, and I'm going to certify that you have no right to appeal, okay? Now, it is late in the day, so you'll need to go ahead and come back to provide us your fingerprints and get we process the paperwork for you. Will you be able to do that on Monday, Tuesday, and Wednesday next week?
Wednesday?
Wednesday, sir. Okay. Understand that you're going to be coming right back here to County Court at law number 2, and you're going to be coming back between the hours of 2 p.m. and before 4 p.m. 4:30 p.m. I'm sorry. Okay, before 4:30 p.m. Sir, if you fail to come back here on Wednesday, the 7th of December, a warrant will be issued for your arrest. Do you understand that?
Yes, sure.
Sir, your attorney has done a fine job for you. 18 months may seem like a long time to be on probation, but you need to take this seriously, okay? I have ordered things here to be able to go ahead and assist you and help you out. You know what your record is, and I know what your record is, and your attorney knows what your record is, okay? Sir, we want to go ahead and make sure that you're successful on probation. So we'll take this seriously and we will cooperate with the DWI court once they go ahead and contact you and have you go through a screening and orientation. Do not fail on that, because now that I have ordered it as a condition of your probation, if you do not attend at least the screening of it and orientation, sir, that will be considered a violation of your probation, okay? And I don't want you to, I want you to be successful on probation. You understand?
Yes.
Okay? Mom needs you.
Yes, she does.
Yes, okay? All right, so we'll see you back here on Wednesday for the fingerprinting, and then we'll go ahead and process from there.
Between 2 and 4:30. correct?
Yes, before 4:30 p.m., sir.
Oh, so I can come in earlier if I want?
Between 2 p.m.
Okay, gotcha.
and before 4:30 p.m.
Okay,
Okay? All right, we'll see you Wednesday.
thank you, Your Honor.
Thank you very much. All righty, counsel will, if there's nothing else, you're excused. Your client is leaving. He'll be back, I guess, on Wednesday.
Thank you.
All righty, thank you.